Certified Spanish interpreter. I have been previously sworn.
Mr. Interpreter, we do have multiple cases this afternoon. I'm going to give you the case number of this first case. It is Renato Miguel Munoz, 2023 MM 1016AO. Let us know when you're ready.
Sí, escucho.
Thank you. Mr. Munoz.
Confirm there is
Okay, thank you. Mr. Munoz, you're here for an arraignment on a charge of disorderly intoxication. The public defender was previously appointed to represent you.
The offer from the state to resolve the case is an adjudication of guilt, credit time served, and court costs. I was not able to speak to Mr. Munoz, being that I don't speak Spanish, Your Honor. I don't know if he wants to resolve the case today.
If you cannot speak to him, he cannot resolve the case today because you are the lawyer to represent him. And the
Well, then-
lawyer needs to be able to speak to the defendant before the defendant can resolve the case. Now, given that scenario, what is his release status? Is it, does he have a bond? How much is the bond? Is it PTR? What's going on? How much?
Looks like 3,000 in total. This is total bond amount.
All right. On this one case, disorderly intox? Or he has other cases?
No, that's the only thing I see.
State, any objection to a reduction in that bond?
Objection, Your Honor.
All right, given the fact that due to a language barrier, he is unable to accept any offer that might be tendered, I'm going to order a reduction in the bond to $250.
Your Honor. What was the amount for the bond?
$250.
Thank you, Your Honor.
Thank you, sir. Then the case will be set for pretrial.
Pretrial March 2nd at 8:45 a.m. in courtroom 4B.
Thank you. And our next case is Luis Gaspar Villanueva Rodriguez, 2023 MO 232AO.
MO 232.
Yes,
Thank you, Your Honor.
Mr. Villanueva,
Sí.
in your case, the court finds probable cause for possession of an open container of alcoholic beverages. Bond will stay set at $250.
Your Honor, there's an offer to resolve the case, and Mr. Villanueva would like to accept the state's offer of an adjudication of guilt, credit time served, and court costs. And it's a plea of no contest.
Mr. Villanueva, is this your signature here at the bottom of this form, sir?
Sí, correcto.
Yes, that is correct.
Sir, did you read the plea form in its entirety before you signed it?
Sí.
Yes.
Do you understand that by entering your plea of guilty or no contest, you are giving up all the rights on the plea form?
Sí, entiendo.
Yes, I do understand.
Are you under the influence of any alcohol, drugs, or medication today?
No.
No.
Do you understand that a conviction on your case subject you to deportation if you are not a U.S. citizen?
Correcto.
Correct.
All right, sir, there's a sufficient factual basis in your case, and you are alert, you are intelligent. I'll adjudicate you guilty, ordered to what time served?
2 days.
2 days in jail, ordered for 2 days' time served. And I will further order that you pay mandatory court costs in this case to the clerk of courts within 365 days of your release. I am releasing you as to discharge, sir. If you have any other cases pending, you must resolve them before you get out of jail. The court takes no action on the other case that he's out on bond on.
Very well, I do understand.
Sí,
Mr. Interpreter, the next case is Jeremy Gisette Cordero Alvarez, case number 2023 CF 1878 AO.
The interpreter can confirm there is connection with the headsets, Your Honor.
Thank you. Mr. Cordero, in your case, the court finds probable cause based on a PC warrant for count one, participation in a public order crime, a RICO enterprise. Bond stays set at $500,000. Count two, participating in the enterprise through racketeering. Bond stays set at $500,000. Three, unlawful use of a two-way communication device. Bond is set to $150. Count four, trafficking in cocaine. Bond is set to $1,500. Count five, leasing or renting for the purposes of trafficking a controlled substance. Bond is set to $500. You are also ordered to comply with the following conditions of release. You are ordered to have no contact with the co-defendants, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Possess and consume no controlled substances unless you have a valid prescription from a doctor. Surrender your passport or certify via an affidavit filed with the clerk of courts if you do not have a passport. And you're ordered to not travel outside of the jurisdiction of the court without the prior permission of the court. Thank you, sir.
Thank you.
Thank you. The next case is Demetrio Garcais, Garcais, 2023 CF 2173 AO. Mr. Garcais, the court finds probable cause for your charge of possession of cocaine, and bond will stay set at $1,000. Thank you, Mr. Interpreter.
I just,
Does Jason Lazou need the interpreter?
Lasso is mental health.
Oh, I'm sorry. Okay, here you go. This is a mental health case, reset it. Madam Prosecutor, would you approach with the defense attorney on this, case, please? As to Jason Lazou, I'm not gonna be handling it because it's a mental health issue, but, I wasn't able to find probable cause for the burglary charge. Yeah, I got the assault, but I missed the behind the register part. Where was that at? So I don't have to reread it tomorrow if he's able to come in the morning. No, Milwaukee, behind the register. noticed that. All right, I'll be able to find probable cause in the morning. I'll just roll it in the morning unless you want to wait. Okay. All right, the defense attorney and the state have approached, and, well, the court is able to find probable cause as to count 1, 2, and 3. Defense is waiving defendant's presence. The court finds probable cause of burglary with an assault or a battery. Count 1, bond is, will stay at no bond. Count 2, battery, bond stays at 500. Count 3, resisting a merchant, bond is set to 150. The defendant is ordered to have no contact with the victims, not return to the location where this incident occurred, possess no weapons, no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. The court revokes the ROR and sets a bond of $1,000 as to that misdemeanor disorderly, well, there are 2 counts, sorry. Revokes ROR and sets a bond of $1,000 on each count. Now, Mr. Interpreter, that we still have another case. You didn't hang up on me, did you?
I'm still here, Your Honor. at
Oh,
your
okay,
service.
good. Well, if you had hung up, we would have just called you back. Octavio Ledesma, case number 2017 CF 13555AL. Mr. Ledesma, you were picked up for failure to appear. Bond stays at no bond in your case, sir. Thank you, sir. Thank you. Does this next case require the interpreter? No. Mr. Interpreter, I'm being told, are we done with the interpreter? I don't want to send him off if we need him back. Yes. Mr. Interpreter, thank you for joining us. You're excused.
At your service, Your Honor. You have a wonderful afternoon.
You do the same. Okay. Jonathan Camilo Moran Hernandez.
Yes, ma'am.
And Ms. Glover Gamble.
Good afternoon, Your Honor.
Yes, ma'am.
I'm here to represent Jonathan Moran Hernandez.
Very well. The court finds probable cause as to count 1, participating in an enterprise through racketeering. Bond stays at $500,000. Count 2, unlawful use of a two-way communication device. Bond stays at $1,500. And count 3, unlawful use of or transportation of currency. Bond stays at $5,000. The following conditions are ordered for release. The defendant is ordered to have no contact with co-defendants, possess and consume no controlled substances unless the defendant has a valid prescription to do so. The defendant is ordered to surrender his passport or certify via an affidavit filed with the clerk of court's office if there is no passport. The defendant is ordered to not travel outside the jurisdiction of the court without prior permission of the court. I'm revoking the bond on the out on bond case.
If I may, Your Honor,
You may.
I'd like to be heard in regards to that.
Yes, ma'am.
It appears that the case that the 2022 case,
Yes, ma'am.
all of that came up at the same time. And the warrant is based upon monies that they seized from him at that time, Your Honor. So there's no new law violation.
State, do you agree with that?
I cannot agree or disagree, Your Honor, only because, and I apologize, the affidavit for this case is over 1,000 pages, so I have not looked at any dates. However, if that is what Ms. Glover Gamble is stating, I will agree with her assertion.
Well, Ms. Glover Gamble, as an officer of the court, I'm gonna take your conclusion on how this came about, and I will not revoke the bond.
Thank you, Your Honor.
All right, thank you. No action. Yes, ma'am. There you go. You're welcome. Patricia Melander Garcia. Do I have, well, maybe did I hand it to you by mistake? No, here it is, but I have Patricia first, but okay. Amron Wrighton. Mr. Wrighton, in your case, I do find probable cause for 3 counts of unlawful possession of a stolen credit or debit card. Counsel, you representing him, state your presence for the record.
Thank you, Your Honor. Good afternoon. Scott Messinger, Smith and Yulo for Mr. Wright.
All right, the court is ordering a bond. You were picked up actually based on a capias, it appears.
That's
And,
right, Your Honor. He turned himself in, actually.
Oh, okay, turned in based on a capias, and bond stays at 2,500 count 1, 500 count 2, and bond is set to $150 on count 3. Now that I realize this is as a capias, I'm actually gonna keep it at $500 on count 3. There's also a failure to appear that I show, and bond, I believe, was no bond on that. Let me see if I got that right. You just have 1 case?
Yes, ma'am.
Hold on a minute then, let me see. No, I have his, I'm trying white. I just need to get the case numbers again. 971, yeah, I have 2 cases. There's, the second case is 2020 CF 3497AO, and it does have the same defendant's name, Amron Wrighton. Failure to appear with no bond. There you go. That's the second one. And, of course, the bonds are set as ordered by the judge who issued the capias on the first case.
And thank you, Your Honor. If I could speak to that, please.
Go ahead.
At this point, the court is not willing to disturb that order, and that remains as said at no bond.
Yes, no, the court is not going to, modify the no bond for the failure to appear, no.
I thank the court. I just wanted to let the court know for the court's information. My client's mother journeyed from New York and would like to address the court. I understand the court has spoken. I respect the court's decision, and I am not going to ask the court to entertain any details on bond from us.
Would you like for me to hear from the mother?
Please, Your Honor.
All right, ma'am, raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Ma'am, what's your name?
Hutchford Nowlin.
What's your last name?
Nowlin, Nowlin. Hutchford
Nowlin.
Nowlin.
Okay. What is it that you'd like to say to the court?
Yeah, my son, okay, yes, he made a mistake, but my son is the one who takes care of me. I'm disabled, and without him, it's kind of hard for me.
Right.
You know, so, I mean, I would appreciate if you could give him a bond, I could try to.
Keep talking into the microphone best you can, ma'am.
I wish you could give him a bond so I can try to help my son get out of this. He will definitely come back to court. I will make sure of that. But I need my son. He helps me out.
Do you have anyone else that can help you out?
My son, he helps me. My son stays with
Do
me.
you have anyone else who can help you out until he gets out?
No, I come from New York to come here to see about my son.
Right.
Hopefully that I could help him get out of here today. Like I said, he's the one who takes care of me. He helps me out.
Okay. Listen, ma'am,
I rely on my son.
this is what I'm gonna say to you, ma'am.
Okay.
First of all, your son is he's in the, I know this is not gonna sound right, so I'm gonna explain it.
Okay.
But he's in the best possible position for somebody who's charged with the crime, and that is he has a lawyer standing right beside him. Now, if he didn't have a lawyer standing right beside him, I'd be a little more concerned about what I'm gonna say next to you.
Okay.
And what I'm going to say is, procedures are in place and that the attorney is well aware of to file a motion with the judge who actually ordered the no bond. There is a judge who ordered that, and that is an independent order by a judge that I'm not that judge's, supervisor or have any greater power than that judge, and I have to respect that judge's order. But the fact that he has an attorney means that the attorney can identify that judge, identify where that case is, and file that motion. The attorney can also communicate with the prosecutor and see if the prosecutor will agree to a bond and then let that judge know. And a lot of times the judges, if we know that the prosecutor and the defense attorney are in agreement about something, a lot of times the judge will go ahead on and, sign it without a hearing. But we do need to know that both sides agree if we are gonna sign something without a hearing. Otherwise, ma'am, your son's attorney can set a hearing and get it before the judge. And I hate the fact that you live so far away, but ma'am, we have procedures in place, and sometimes they aren't perfect for every scenario that can be envisioned, but it's the best that we have right now, considering the circumstances. But I do feel for you, especially considering that you really rely upon your son. However, things can be expedited, given the fact that someone has a lawyer and they can attempt to get the case before a judge as quickly as possible. Now, I cannot guarantee you days and times and moments, but I can tell you that having a lawyer who is committed and cares enough to come to court and follow up is the best possible scenario for your son. I'm sorry if I can't be of any other assistance.
Okay, thank you, but when will he go back to court?
Well, it really does depend on, everyone gets a court date after they come to court here. But him going back to court on the actual no bond case, what you're concerned about, because he does have a bond on the new cases, okay? Or the.
He has a bond?
Yeah, but he has a no bond for failure to appear. So that's the one that I'm thinking you're the most concerned about, because he can't get out of jail on the failure to appear. So that means it has to be initiated by lawyers. The lawyer can set a hearing for it, or try to set a hearing for it. Or, as I said earlier, perhaps get an agreement from the state.
But the time that he had the court case to come back, the COVID was going on. So it wasn't no movement at all. Because someone from the courts or someone called me containing my son, and my son supposed to had a video, I think.
So let me just stop you right there.
Okay.
Now, in one of the cases, the judge did sign a capias and give a bond. And in the other case, the judge gave no bond for failure to appear. So the judge, and I'm a judge, and and I went through COVID too, and I know a lot of times what we judges do is we look at the paperwork and we see what kind of notice we sent, and we go by that. And now, if the judge is convinced that the appropriate notice was given to the defendant, regardless of it being COVID or some other circumstance, we may issue a capias and we may order no bond. But at the same time, ma'am, I can't give you the answers that you want during this short, brief hearing, and I have a bunch of other cases. But I can tell you what I said earlier and just repeat that if Mr. Messenger is your son's attorney, he's in the best possible position to get these matters addressed. And I just have to just leave you with that reassurance, and that's all I can do. And of course, Mr. Messenger invited you or informed you that you could be here today to talk to me. And so I just encourage you to reach out to Mr. Messenger after this hearing and get some guidance as to what next steps are, since he is representing your son as his lawyer.
Otherwise you're telling me he's not going to have a court case no time soon. I'm trying to figure out.
Well, I never said that, ma'am. Ma'am, I never said that. Now, I do understand that I'm not telling you what you want to hear. I'm well aware that I am not telling you what you want to hear. But I am telling you what is correct. Have a good day, ma'am.
Okay, thank you.
I thank the court, Your Honor, and I thank the court for explaining to,
Well, I do my best. Sometimes I fall short. But I'm glad to see that he has you, Mr. Messenger.
I thank Your Honor.
Okay.
Okay, so I will get you in. I will get you.
Yeah, okay, I'm gonna call you. I'm gonna call you right here too.
Patricia Melander Garcia.
Good afternoon, Your Honor. Samantha Lambert on behalf of the defendant.
All right, Ms. Melander, you were picked up for DUI driving while under the influence. Bond will stay at $500. This is the case where the court is very concerned about some of the issues surrounding the DUI. And I've been considering whether to order the SCRAM monitoring device, or at least I think this is the case. Madam Clerk, did you all take a little note, sticky note off the top of here? No. You would never do that, right? If you saw a sticky note, it stays, right? Okay, wait a minute, let me just be sure.
No problem.
I know I put it, I don't want to order SCRAM if it's not the case that I wanted to order SCRAM on. Okay, it's not the case that I wanted to order SCRAM on, so sorry. I didn't mean to scare you like that. But she does have a violation of probation on her driving while license suspended with knowledge that I think is set in front of Division 85, and that would be me.
Yes.
And I was really concerned about that, and I was thinking I might revoke her bond and give her no bond on that.
May I briefly be heard on that issue?
Yes.
It is fortunate that it is in front of Your Honor.
Okay.
So in that violation of probation, she pled out on the Dwillis on May 31st. Subsequently, in a case in front of Judge Carter, she was deemed incompetent to proceed on July 29th, 2022. Since that date, there's been no other evaluation, although Judge Carter just ordered a new evaluation on February 1st. So there's that aspect, which I know she's not incompetent in this case. And then secondly, the violation of probation was for a new law violation, which was no infoed by the state on December 30th, 2022. So that's
Well, but this is a new law violation too, and she's still on probation. But, okay, you're giving me some insight about potential mental health issues or incompetency, and I thank you for that insight. I tell you what, I'll base it on whether or not that case was no info or not for the VOP. State, can you confirm that or not?
Yes, Your Honor, it does appear as though the defendant was arrested for loitering or prowling, 22 MM 7270, and was subsequently no billed.
Okay, so I'll base my order on that and I will not revoke the bond. But I am really concerned about her getting behind the wheel of a car. So I'm going to order that she not drive without a valid driver's license as a condition of release. And ma'am, that essentially means that, well, I don't know who's gonna get this other DUI case, but I just don't want her driving a car. Hopefully she won't drive a car.
That is unbelievably reasonable and fair, so
Okay.
thank you. Have a good day.
You do the same. Okay. And these won't have these sheets either, right? Okay. Oh, do I just have one? Oh, there's only one. Okay. Do I have some more?
You do have it.
Okay, but they're just not ready yet. Okay, Van Michael Brown.
Yes, ma'am.
Sir, you're here for an arraignment. There's no attorney in this case, so if you need the public defender, then I'm gonna have to have you apply for the public defender, but there are 2 counts: violation of an injunction for protection against stalking, cyber stalking, telephone or contact. And again, this is your arraignment, and if you want to have an attorney to represent you, cannot afford to hire one, then I'll appoint the public defender.
Hey, ma'am, I've been in Pennsylvania for a year.
Do you want me to appoint them?
Yeah, but I've been in Pittsburgh, Pennsylvania. I come back here and they put, I don't know what's going on.
Well,
Know what I'm-
I can help you with that. I am appointing the public defender because you have requested them, you qualify, and the public defender is going to now be your lawyer, and they will be able to tell you what's going on, or should be able to tell you what's going on.
Yeah, I was in Pennsylvania for over a year and I come back here and they put me in jail. You know, I don't have nobody down there to help me, you know.
You now have the public defender, sir.
Okay, can you release me on my own reconnaissance or something?
No, I will not be addressing any release issues at this time. The case will be set for pretrial.
March 6th at 9 o'clock in courtroom 4E.
Now, sir, let me just reassure you, Ms. George, let me reassure you that now that you have the public defender to represent you, and hopefully the file will be documented that you seem to have some mobility issues and that,
I don't know what the problem is down here.
yeah, well, listen to me. Then the public defender can schedule a hearing before the judge that's assigned to the case to try and address your concerns about being released, okay?
Okay, ma'am.
All right, thank you.
Thank you, ma'am. Thanks.
Kirkpatrick Burks, Jamal Burks. Are you Mr. Burks? Hello? Are you Mr. Burks? Okay. The court finds probable cause in your case for trespass on property after a warning, and I'm setting a bond of $500.
Your Honor, there's an offer to resolve the case with an adjudication of guilt, credit time served, and no return to 3250 Burton Boulevard, as well as court costs. Mr. Burks would like to accept the state's offer and enter a plea of no contest. Got it?
Mr. Burks, sir, is this your signature here at the bottom of this plea form?
Yes.
Did you read the plea form in its entirety before you signed it? Or did the lawyer go over the plea form with you in its entirety before you signed it?
Yes, you did.
Are you under the influence of any alcohol, drugs, or medication today?
No.
Do you understand that a conviction on this case will subject you to being deported if you are not a United States citizen? You understand that?
Yes.
All right, sir, there is a sufficient factual basis to accept your plea, and you are alert, you are also intelligent, and I'm gonna adjudicate you guilty. Time served?
2 days.
Order 2 days in jail, credit for 2 days that you have already served. Further, sir, I'm ordering you to not return to 3250 Bruton Boulevard in Orlando, Florida. You are also ordered to pay mandatory court costs within 365 days of your release. Pay it to the clerk of courts, and I am ordering you to be released today as to this charge. Do you have any questions?
How much is that?
The exact amount is gonna be included on your paperwork, but the clerk is telling me now how much?
$173 total.
Okay. Did you catch that? Thank you, sir. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. Clyde Griffin III.
His behavior.
I'll reset, I'm gonna ask to reset for tomorrow. There's an offer, Your Honor.
All right, reset this for in the morning, please. Or no, not in the morning, tomorrow afternoon. So, second session. Okay, Bashoko Batsil? Batsil? Is that who you are, ma'am? Or sir, am I mispronouncing your name?
No, that's correct.
That's correct, okay. You're charged with possession of 3,4-methylene MDMA ecstasy. Bond will stay set at $1,000. Jonathan Belcher? Belcher? In your case, you were picked up on a probable cause warrant for carjacking with a firearm. Bond is gonna stay at no bond.
Yes, ma'am.
Conditions of release are do not possess any weapons or firearms, do not possess or consume any alcohol or illegal drugs without a valid prescription, and have no contact with the victim.
Yes, ma'am.
Thank you, sir.
Your Honor, is there also a condition to have no contact with co-defendants?
Well, I can add that if the state is requesting it.
Yes, please.
You're also ordered to have no contact with co-defendants.
Yes, ma'am.
Thank you, sir. Deshaun Roberts. Mr. Roberts? Yes, sir. Sir, in your case, the court does find probable cause for loitering or prowling bond stays at $250. Possession of burglary tools, bond stays at $500, and burglary of an occupied structure, bond stays at $3,500. You're ordered to have no contact with the victim, not return to the location where this incident occurred. You have a case where you're out on bond, sir, and the court's gonna revoke that bond. As to count one, I'm ordering a new bond of $2,000. As to count two, I'm ordering a bond of $1,000. A new bond of $1,000. Thank you, sir. Justin Taylor.
Defense away.
All right, defense is waiving, and of course, I am appointing the public defender. Court finds probable cause as to count one, bond stays at $4,000, count two, bond stays at $500. The court's revoking the ROR on the defendant's out on bond case and ordering, a bond of $1,000 on each count. Okay. Y'all just wreak havoc on my vocal cords when I come out here to the jail. I've already had like 4 calls. Oh, thank you, Ricola. Thank you. And then I had all kinds of water. I haven't had my tea. See, that's what it is. I haven't had my tea. No, and also with all the talking and just kind of pushes up stuff, I'm definitely gonna suck on this and try to talk at the same time. Hopefully I won't swallow it whole. But thank you for this. Oh my gosh, you're a lifesaver because I've already sucked all mine. What kind is this? Honey lemon echinacea. This is the best one. I love this honey lemon echinacea. I'll get you this one. Okay, thank you. Got me some that might get me over to tomorrow. Yeah. One last day. Thank God for the microphone. I am so sorry, everyone. My vocal cords, they start really doing their thing. Mac Kelly. No, Mac Kelly. Is he somewhere? Did he bond out? Mac Arthur Kelly.
The booking number for him, Your Honor?
Madam Clerk, what's the booking number?
We're on arraignment.
23004067.
He's still here, I think. You guys, yeah, I think they just have arraignments ready now, Your Honor.
Is he in arraignments? In my arraignment stack? Well, did I move him or something? Oh, okay. Okay, don't bring the defendant in here yet. Can I have a tissue? Yeah. You guys don't have soft tissue? I want it. The clerk the other day had tissue.
We have you for tomorrow. I have some in the car.
Okay. Court's gonna take a 5-minute recess. I need tissue. Oh,
Pre-trial, March 6th at 8:30, courtroom 6C.
thank you. John Wesley Blanc. Mr. Blanc. You're here for your arraignment as to a charge of criminal mischief with damage of more than $200. The public defender was previously appointed.
We're gonna enter a plea of not guilty.
We're resetting your case for pretrial conference.
Pre-trial, March 6th, 9 o'clock, courtroom 4E.
Thank you. Joshua Matthew Boyd.
That's it.
Joshua Boyd. All right, Mr. Boyd, you are here for your arraignment on a charge of resisting an officer without violence. The public defender was previously appointed in your case, sir.
We're gonna enter a plea of not guilty.
All right, sir, your case will be set for a pretrial conference.
Pre-trial, March 6th, 9 o'clock, courtroom 4E.
Thank you. Willie Joseph Carr. Mr. Carr, sir, you're, here for an arraignment on a charge of trespass in a conveyance. The public defender was previously appointed in your case.
Yes, ma'am.
The offer from the state is an adjudication of guilt, credit time served, and Mr. Carr would like to accept it into a plea of no contest.
And is the defense able to stipulate that there's a factual basis in that case?
Yes, Your Honor.
Thank you. Mr. Carr, is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it or discuss it with your lawyer in its entirety?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine today?
No, ma'am.
You understand that by entering your plea of guilty or no contest, you're giving up all the rights on the plea form?
Yes, ma'am.
You understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? You understand that?
Yes, ma'am.
All right, sir, there's a sufficient factual basis in your case. You're alert, you're intelligent. How much was that time served?
19 days.
I'll adjudicate you guilty and order 19 days in jail with credit for 19 days time served. I am going to order you to be released as to this charge today, sir.
Yes, ma'am.
I am also ordering you to pay mandatory court costs to the clerk of courts within 365 days of your release. Do you have any questions?
No, ma'am.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You're excused. John Robert Faylor.
Yes.
John Faylor.
Yes, ma'am.
You're here for an arraignment on a charge of disorderly conduct,
Yes, I'm here.
and the public defender was previously appointed.
And the offer from the state is an adjudication of guilt, credit time served. And Mr. Faylor would like to accept the state's offer into plea of no contest, and defense will stipulate to a factual basis.
Thank you, ma'am. Mr. Faylor, sir, is this your signature here at the bottom of this plea form?
Yes, ma'am.
And did you read this plea form in its entirety before you signed it?
Yes, ma'am.
Do you understand that by entering your plea of guilty or no contest, you're giving up all the rights on the plea form?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine at this time?
No, ma'am.
Do you understand a conviction on your case will subject you to being deported if you're not a U.S. citizen?
Yes, ma'am.
All right, sir, there's a sufficient factual basis based on stipulation of counsel, and you are alert, you are intelligent. You're adjudicated guilty in order to serve 42 days in jail with credit for 42 days time served. I am ordering your release as to this case today, and I am ordering you, sir, to pay mandatory court costs within 365 days of your release to the clerk of courts. Do you have any questions?
Right now, I just want to get some more programs before I can stay off the street.
Sir, I hope you can find a way to stay off the street too. Good luck with that. And you have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Keith Stewart, in your case, you're here for an arraignment on a petty theft charge, and the public defender was previously appointed.
The offer from the state is an adjudication of guilt, credit time served, no return to 8001 South Orange Blossom Trail. And Mr. Stewart would like to accept the state's offer and enter a plea of no contest, and we will also stipulate to a factual.
Thank you. Sir, is this your signature here at the bottom of this plea form?
Yes, Your Honor.
And did you read this form in its entirety before you signed it or go over it with your lawyer?
I did, Your Honor.
Do you understand that by entering a plea of guilty or no contest, you're giving up all the rights on the plea form?
Yes, Your Honor.
Are you under the influence of any alcohol or drugs or medicine this afternoon?
No.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
I do, Your Honor.
There is a sufficient factual basis to accept your plea, and you're alert, you're intelligent, you're adjudicated guilty, ordered to serve 37 days in jail with credit for the 37 days that you have served. You're further ordered to not return to 8001 South Orange Blossom Trail in Orlando, Florida. Further, sir, you must pay mandatory court costs within 365 days of your release, and I am ordering you to be released today as to this charge. Any questions?
No, thank you.
You have the right to appeal. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Elmer Tossi. Mr. Tossi, In your case, you're charged with battery. The public defender was previously appointed. This is your arraignment.
We're gonna enter a plea of not guilty.
Plea of not guilty entered set for pretrial conference.
Pretrial, March 30th at 8:30 a.m., courtroom 9B.
Thank you. Danielle Marie Harger. Ms. Danielle Harger,
She's mental health, Your Honor.
mental health.
We'll waive and enter a plea of not guilty.
All right, I'm gonna have to, oh, this is an unusual situation. She doesn't have a public defender. No public defender's been appointed. She's mental health. Where is she? Are we able to get her an application for the public defender? Uh-huh. Well, I'm gonna appoint the public defender. Miss George, I'm appointing the public defender.
And we will waive and enter a plea of not guilty.
All right, your office can follow up with getting the actual form filled out by the defendant. I'm appointing her based on the fact that she is a mental health, and couldn't be in court today, and that she is incarcerated and unable to, probably unable to have income. The case will be, go ahead and set the case for pretrial conference, please.
Pretrial, March 24th at 9:30 in courtroom 7C.
Thank you. Arthur Matt Kelly. Okay, sir, there's probable cause for your charge of trespass on property.
And the offer from the state is an adjudication of guilt, credit time served, and no return to 1200 West Colonial Drive. And Mr. Kelly would like to accept the state's offer and enter a plea of no contest.
Thank you. May I have a plea form? How much time served? 2 days? Mr. Kelly, is this your signature here at the bottom of this plea form? Yes. And did you read this document in its entirety or go over it with your lawyer in its entirety before you signed it?
Yes.
Are you under the influence of any alcohol or drugs or medicine? No. Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen? All right. So I find that there is a sufficient factual basis to accept your plea, and you're alert, you're intelligent. You're adjudicated guilty in order to serve 2 days in jail with credit for 2 days' time served. And you are ordered to not return to 1200 West Colonial Drive in Orlando, Florida. Further, you must pay mandatory court costs within 365 days of your release from jail. Pay it to the clerk of courts. And I am ordering your release today as to this charge. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days. Do you have any questions? Thank you, sir. Larry Odoms?
We reset for tomorrow. There is an offer to resolve, Your Honor.
Yes, due to mental health, we're gonna reset this for in the morning, all right, tomorrow, just not in the morning. Robert Parsons?
Yes, Your Honor.
Sir, I find probable cause for the charge of trespass on property after a warning.
And there is an offer to resolve the case with an adjudication of guilt, credit time served, no return to 5524 West Colonial Drive. And Mr. Parsons would like to accept the state's offer and enter a plea of no contest.
All right, and that's 2 days credit?
Yes, ma'am.
Mr. Parsons, is this your signature here at the bottom of this plea form, sir?
Yes, Your Honor.
Did you read this document in its entirety before you signed it?
Yes, ma'am.
Do you understand that by entering a plea of guilty or no contest, you are giving up all the rights on the plea form?
Yes.
Are you under the influence of any alcohol, drugs, or medicine?
Not as of, not then and not as now, no.
I'm sorry,
Not then and not as of now, no.
not now?
No.
Okay. Do you understand a conviction will subject you to deportation if you are not a U.S. citizen?
Yes.
All right, there's a sufficient factual basis, and you're alert to accept your plea, you're alert, you're intelligent. I will adjudicate you guilty, order 2 days in jail with credit for 2 days' time served, and order you to not return to 5524 West Colonial Drive in Orlando, Florida. Further, you must pay all mandatory court costs within 365 days of your release. Pay it to the clerk of courts, and I am ordering you to be released as to this charge today. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir.
Thank you.
Lindsay Canales Pena,
She bonded.
previously bonded. This is the case that I would have ordered scram on, but she already bonded. Michael Dorsey,
He bonded.
previously bonded per jail staff. What else do we have? Any igniting,
Schneider?
heresy? Sir, there's probable cause in your case for driving on a suspended license with knowledge. Bond stays at $500. The court is going to take no action on one of your out-of-bond cases. But I am I'm revoking your bond on your other out-of-bond case number 2023 CT 992AO. There was a bond of $500. I'm revoking that, and I am ordering a bond of $1,500. No action on the 2023 CF case. Oh. Let's go. I don't know what I did with it. Oh, I messed it all up. Ashley Jones,
She bonded.
bonded per the jail staff. There you go. She qualified for PTR. Marquise Seabrooks, bonded per the jail staff. Deontay Anderson, bonded per jail staff. Lloyd Birch. All right, Mr. Birch, sir, you were picked up for failure to appear, 2 counts. Bond stays at no bond on each of those counts. Michael Cardona,
Your Honor, I will waive, but I would also ask that you ROR as to 1 count of resisting an officer without violence. The state can only move forward with 1 when it's stemming from the same incident, even though there's multiple officers involved.
so, state, were these the same incident?
Yes, Your Honor.
All right, the court finds probable cause only in case number 2023 CF 2171 AO. Bond stays at 1,000 on count 1, 250 on count 2, and the court sets a bond of 150 on count 3. The defendant is ordered to not return, have no contact, not return to the location where this incident occurred. As to 2023 CF 2172, the court does not find probable cause and orders the defendant be released on recognizance. William Cicera?
Yes, Your Honor.
Sir, in your case, the court finds probable cause for count 1, 2, and 3, aggravated assault with a deadly weapon, bond stays at 2,500. Battery on a uniformed or licensed security officer, bond stays at 150. Trespass on property after a warning, bond stays at 100. You're ordered to not return to the location where this incident occurred.
I pled innocent, Your Honor, and I asked for bail. I'm 71 years old. I just came down here from New Jersey, where I live, and I was in the hospital down here by the on Orange Avenue, and I was stopped at a junction, and my things were stolen. So I went back the next day, and an officer gave me the things. But then I went back the next day, and I asked at the place, and I got a little argument, and that was about it. One of the junctions in Florida. Usually I'm down toward the lake or the Gold Coast, Boca Raton, or that way, Miami or so.
All right, thank you, sir.
So, thank you.
Miss George and Miss Eugene on that last case, please approach. Miss George, I'm sensing a competency issue with the last defendant. So maybe if you just document something in the file that the attorney who gets assigned to the case knows to start looking into whether competency might be a concern with him. Thanks. Thank you. Mr. Conyers, the court did find probable cause in your case, does find probable cause for count 1, possession of cocaine. Bond stays at 1,000, and count 2, counterfeiting a license plate. Bond stays at 150. The court is revoking your out on bond case and ordering a new bond of $2,000. Durell Artez Cooley.
Yes, ma'am.
And sir, you were picked up based on a probable cause warrant for attempted first-degree murder with a firearm. Bond will stay at no bond. You're ordered to have no contact with the victim.
And who was that?
Who is that?
Yes, ma'am.
DeMarcus Miller.
My nephew?
DeMarcus Miller, a part of the state.
My,
Sir, you do have another matter that I need to discuss, and that is that you were out on a bond in a 2022 case, CF 9829AO, and the court revokes the bond and says no bond on both 1 and 2, count 1 and 2. No bond. DeJuan Dennis.
yes, ma'am.
Dennis? Sir, in your case, the court does find probable cause for possession of cocaine. Bond stays at 1,000, and possession of paraphernalia, the court are ordering a release on recognizance. The court is taking no action as to your 2 out on bond cases. Roy Detreville. Mr. Detreville, the court does find probable cause in your case for both count 1 and count 2 based on a PC warrant. Sexual battery on a child under 12. Both counts are sexual battery on a child under 12. Bond will stay at no bond for count 1 and count 2. The court is ordering that you have no contact with the victim, and I'm also ordering that you have no contact with any minor as a condition of release.
That's it.
Marcus Atkins, you were picked up for violation of conditions of pretrial release. Bond will stay at no bond. Janelle Glover, Jeremiah Glover, sorry. Glover?
Yes.
All right, the court does find probable cause for fleeing and attempting to elude a police officer. Bond stays at 4,005. Well, actually, you do qualify, I notice here for PTR. Is that correct, Ms. PTR?
Yes, Your Honor, he
All
does
right,
qualify.
so, sir, I'm gonna order, instead of a bond, I'm ordering you to be released on the pretrial release program.
you want any conditions with that, Your Honor?
Comply with all conditions of pretrial release. State, do you have any additional, requested conditions?
No, Your Honor.
Thank you. Michael Gray? Yes, sir. In your case, the court, does find probable cause for aggravated battery with great bodily harm with a firearm. State, now I might need your insight on this. I think I'm gonna give him a bond of $10,000. Does the state have any objection to that?
No objection, Your Honor.
Okay. I'm gonna set a bond of $10,000 in this case. I'm ordering that you have no contact with the victim.
Thank you, Your Honor.
And that you possess no weapons and no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of release.
Your Honor.
Antonio Hopkins.
Defense will waive.
Defense is waiving. The court finds probable cause. Bond of 1,000 remains. Liger Jean Charles. Bonded per jail staff. Bernardo Jurinack. Jurineack. Jurinack. Oh, I don't know. I don't have numbers.
2300460.
They bonded.
Previously bonded per jail staff. Christopher King.
Defense will waive.
The court finds probable cause for burglary of an occupied structure. Bond stays at 5,000, and loitering and prowling. Bond stays at 250. The court takes no action on the out on bond matter.
Your Honor, you said it stays at 5,000?
Yeah, due to someone submitted some type of a correction on the bond and asked the court to set 5,000.
Okay, thank you. Is that a no return as well, Your Honor?
Yes, the court is ordering that the defendant not return to the location where this incident occurred. Condition of bond. Julia Kirkland. Bonded per the staff. Brent Sean Lee.
Yes, ma'am.
The court finds probable cause for possession of heroin, more than 10 grams, and, bond, ma'am?
I was gonna argue no PCS to the 10 grams. I believe it's simple possession. The affidavit does not state that he had 10 grams of heroin.
Okay, well, what says the state?
No objection, Your Honor.
The
It's a
court,
mistake.
the court will just find probable cause for simple possession, and bond will stay at $1,000. And probable cause for larceny, bond stays at $250. The court is also noting that you were picked up for an on-view VOP violation of probation, and bond will stay at no bond.
Your Honor, with regard to the theft, can I ask for a no return?
Yes, the court is ordering no return as a condition of bond on the petty theft or the theft charge. John Doe,
Wolf Lindor?
I don't know who John Doe is.
Ralph Lindor.
Mr. Lindor? All right, also known as John Doe. Mr. Wolf Lindor, I have here that you failed to appear on 2 counts. Bond will stay at no bond on both counts. Thank you. Akeem Levitt,
Yes, ma'am.
you were picked up on a probable cause warrant for burglary to an unoccupied structure. Bond stays at $2,500. And grand theft, bond stays at $1,500. You also have another case, where you were picked up on a PC warrant. Burglary of a structure, bond stays at 5,000. Grand theft, third degree, bond stays at 2,500. And criminal mischief, bond stays at 1,000. The conditions of release are that you not return to the location where these incidents occurred in both cases, have no contact with the victims, possess no weapons or firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release, and that you possess no drugs and no alcohol as a condition of release. I am ordering you to be subject to random substance abuse, drug and alcohol analysis through pretrial release as randomly scheduled by pretrial release. Thank you, sir.
And that's on both cases, Your Honor?
I'm sorry. As to the no drugs or alcohol, that is only as to case number 23 CF 1365 AO. That condition is not a condition on the other case.
Okay.
Yes, it's on the 2023 case, the random substance abuse, random, yeah, that's just only on the one case. All right, Jasmine Mall, Ms. Mall, I've been informed that you have an attorney on your case by the name of Richard Hornsby.
Yes, ma'am.
And Mr. Hornsby has requested through the clerks that we reset this case for in the morning. And he wants to be present
Okay.
on your behalf. So I have informed the clerk to tell Mr. Hornsby I'm going to reset this case.
Okay, thank you.
All right, so we'll reset it for in the morning?
Yes, ma'am.
All right, we'll recall this in the morning. Do I give you this back or do I keep it? Because I wrote a lot of notes on here. You're not gonna lose my notes, are you? Because I read this, read it again. I read it. I went to the file, I pulled it, I read it, and I did research on it and everything. Please don't lose my notes. There you go. William McGillivray.
Yes, ma'am.
In your case, the court finds probable cause for your charge of failing to register as required as a sex offender. I'm setting a bond of $1,000. You're ordered to comply with all reporting requirements within 24 hours of your release from incarceration. Thank you. Demetrius McIntosh. The court finds probable cause for your count 1, carrying a concealed weapon. Bond stays at 2,500, and count 2, possession of cannabis greater than 20 grams.
And I was gonna argue no PC. It was not tested, Your Honor.
What says the state? She says it's no PC due to not testing.
It was not tested, Your Honor.
And then any objection to a release on recognizance on count 2?
No objection.
No PC and release on recognizance, sir, as to count 2. And you do have another case, sir, 22 CF 11395 AO. The court is revoking the bond and ordering no bond on all counts.
Your Honor, with regard to the new law offense, the carrying the concealed weapon, are you keeping that bond as is at 2,500?
Yes, I kept that at 2,500.
Thank you, Your Honor.
One final thing, sir. I am ordering that you possess no firearms or weapons and surrender all firearms or weapons to law enforcement within 24 hours of any release.
And Your Honor, I would ask that you consider revoking and doubling. He has no other, looks like history. I know he has some arrests, but he's never been convicted.
What says the state?
Your Honor, I understand the defense's position, but he's out on bond for carrying a concealed firearm and is picked up for the exact same thing.
That was the court's concern, so therefore I will deny that request at this time.
I think it's Samantha Lambert. You have an attorney?
Dominique McNutt.
Dominique McNutt, ma'am.
Ms. McNutt, You were picked up for failing to appear. Bond will stay at no bond. Christopher Pierre. Bonded per the jail staff. Y'all see I'm moving much slower now.
I can hear you.
It's like a marathon. You start out fast, but you get slower as time progresses. Marcandi Pierre.
Yes, ma'am.
The court finds probable cause for grand theft, third degree of a motor vehicle. Bond will stay at $3,500. You also, sir, were out on a bond, on recognizance on another case, 2022 CF 550AO. And I'm revoking that bond, or revoking that ROR, ordering a bond of $1,000 on both counts.
I believe
You
you
are
filed
also-
on one count, Your Honor.
Which count was filed? Was it the carrying or
I think
concealed
it
or
was
the?
the carry and concealed.
Okay, no revocation of the ROR on count 2 then, just as to count 1. And ordering you to possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. And Porter Aurora. Or it might be Aurora and Porter. In your case, the court finds probable cause for possession of 3,4-methylene methamphetamine ecstasy. Bond stays at $1,000. No action on your out on bond case, ma'am.
Thank you. Love to see it.
Jordan Reed.
Yes, Judge.
The court finds probable cause for possession of a short barrel gun, rifle, or machine gun, count 1. Bond stays at $10,000. Count 2, carrying a concealed firearm, bond stays at $5,000. Count 3, carrying a concealed firearm, bond is set to $500. Count 4, carrying possession of cannabis less than 20 grams, bond is set to $150. Count 5, possession of a short barrel gun, rifle, or machine gun, bond is set to $500. You're ordered to not possess any weapons or firearms as a condition of release and surrender all weapons or firearms to law enforcement within 24 hours of release. Any other conditions recommended by the state?
No, Your Honor.
Thank you.
So, what, I missed the bond on count 2.
5,000. Brayon Dextani Rents.
Abraham Dexter.
Are you Rents?
Yes, ma'am.
You were picked up for battery while wearing a mask. Based on a PC warrant, the court does find probable cause and bond will stay at $2,500 with the following conditions: that you have no contact with the victim, no contact with any co-defendant, and no contact with any witnesses involved in this case, that you not return to the scene where this happened, that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Thank you, ma'am. Malik Sims. Bonded per jail staff. Scott Tavernier.
He also bonded?
Bonded per jail staff. Mark David Victor.
Yes, ma'am.
Mr. Victor, the court finds probable cause for tracking in methamphetamines greater than 14 grams. Bond stays at $50,000. Count 2, possession of cocaine. Bond stays at $150. Count 3, possession of a controlled substance. Bond stays at $150. Count 4, possession of drug paraphernalia. The court will ROR you on that count. I'm revoking your 2 out on bond cases. I'm revoking the bonds on both cases. And as to 2022 CF 3335 AO, bond is set to $4,000. As to case number 2022 CF 7871AO, bond is set to $1,000. Ashley Darrell White. The court, you were picked up for failure to appear on multiple counts, 3 counts, bond stays at no bond on those 3 counts. In your second case, you were picked up for failure to appear, bond stays at $1,000. And your third case, you were picked up for failure to appear, bond stays at $1,000. Rashad Wilson Darian. In your case, you were picked up for possession of cocaine with intent to sell or deliver. Bond stays at $15,000. And I am revoking your bond on cases where you are out on bond. In one case, it looks like you were, maybe have been on PTR. I don't understand this. It says a bond of $2,500, then it says PTR, then it says diversion. So I don't know what his current status is.
It's pretrial diversion, I believe, Your Honor.
Oh, so he is on pretrial diversion?
Was accepted in a PTD, yes.
Okay. Did the judge ROR him on that case, and or does he still have the bond on that case? 2022 CF 6276 AO. Yeah. You got that. Well, in the other case, there is a bond, that's 2023 CF 1987 AO. I'm revoking that bond. I am ordering a bond, a new bond of, as to count 1, $2,000, as to count 2, $2,000 for a total of $4,000. So as to that case, can you give me some information on the other case? They discharged it? Okay. So, sir, you're currently on our ROR status on case number 2022 CF 6276 AO, and I'm revoking that and ordering a bond of $5,000. Oh, that's my last file. Are we done?
Your Honor, for this,
Wait a minute, there was the case PTR, the case that we were working on with Bribin.
Yes, Your Honor.
Any update?
Yes. It looks like we have not heard back from the facility at all. So I guess we'd be looking to strike the PTR and then just set bond for him so that he can bond out and go to whatever place is appropriate for him since PTR.
All right. I want to go ahead and formally call that case on the record then. I don't have the case in front of me. I just remember the fact that I had the case. I just don't remember the defendant's name.
I'll get that for you. 1 second, Your Honor. It's defendant Julio Vasquez, and the case number is 2023 MM001046 AO.
Very well. The court is amending the release order that I entered yesterday on that case. Do you all, are you all ready? No. Okay. At the beginning of court, I think I identified the case for you all, so you can get some paperwork ready on it. Can you repeat the case number for us?
Sure.
Thank you.
It is 2023 MM001046 AO.
And Madam Clerk, let me know when you're ready. Madam Clerk, does it show that I appointed the public defender on that case? Yes? Okay, very good. And can we call the name again for the benefit of the public defender?
The name is Julio Nelson Vasquez.
Ms. Public Defender, Ms. George.
Yes.
Julio Vasquez is, before this incident happened, was in an institution of some sort, or facility. And the facility, PTR contacted the facility, and they are unable to confirm that they'll take him back before he's seen by their own doctor. I had released him PTR. The best we can do is take the PTR off the table, because PTR can't really supervise him, and, because he has dementia. And I'm gonna order a bond of $500. And just a little more information, the incident actually happened at the facility where he was residing. So I originally ordered PTR with no contact and no return. Now I'm gonna take the PTR off and order a $500 bond, still keep the no contact and no return. But you may want to document in your file that the facility will take him back if their doctor evaluates him and gives them the green light to take him back. So there may be some, concerns with the family being able to monitor him due to the medical status of dementia. We were hopeful that the doctor would be able to do something quickly, but there was just, it's too quick of a turnaround.
And can I just get the case number?
Yes.
2023 MM104680.
We just don't want him to, wind up being in a situation where he is not taken care of due to the medical status.
Yes, Your Honor. I will document.
So, Your Honor, just to confirm, essentially what is being changed is, it's being changed from PTR to a $500 bond. Everything else remains the same?
Yes, PTR informed me that it would be very difficult for them to monitor him due to the dementia status. And also there was concern as to we wouldn't know where he would go. The family may need to get together to try to figure out whether they can post his bond. I don't know if there's any other matter that needs to be addressed on the record. Ms. Eugene, did you have something?
No, Your Honor. Nothing from this date.
Okay. I thought I heard somebody say something. Ms. George, was it you?
No, nothing from defense, Your Honor.
Okay, well then, am I making that up in my head? The clerks didn't say anything?
No, Judge.
Deputies? And I know the PTR lady didn't say anything, because you would have jumped up and said, Judge. So we're in recess. I made that up in my head. Sir, you're in court this morning based on a fugitive warrant, and I understand you have an attorney? All right, do you, have you had contact with your attorney?
Not as yet. My girlfriend got him yesterday.
Okay, is your attorney local or is your attorney in the other state?
He's in Georgia.
Okay, so if you are asking to speak with your attorney first, that's fine. I can give you the time to do that, but you're gonna remain incarcerated until I don't know what's gonna happen first, but I will give you the opportunity to communicate with your attorney if that's what you want. Yes, so you do not want the court to take any action other than to allow you time to talk to your attorney?
Yeah.
All right, then no action will be taken on your case. Yes. Yeah, we'll reset it for 1 week. Yes, 1 week from today. Okay. This is Justice Hazel Ford.
Yes, Your Honor.
2023, good morning, CF 453AO. Good morning, council.
Good morning, Your Honor.
Announce your presence for the record.
Elizabeth Fryer on behalf of Mr. Fort.
Yes, ma'am.
Your Honor, we're here on an unopposed 33-day motion where there's been a notice of non-filing. I've prepared proposed order that's been reviewed by Mr. Altman in the State Attorney's Office and also submitted that to Ms. Bell.
Mr. Altman is still with the State Attorney's Office?
He is.
Okay.
I have hard copies, but I've also sent one to Ms. Bell. May I approach?
I think I have one.
You do.
Yeah, I already have one. And so Ms. Bill must have forwarded it. And state, you agree that there's no objection? And announce your presence for the record, please.
Brenda Eugene, on behalf of the State Attorney's Office. No, there's no objection to the motion, Your Honor.
All right, the motion is hereby granted. Today's date? Okay.
Thank you so much, Your Honor. That's all I have today.
Well, I haven't seen you in forever either.
I think it's been over a decade since I've
Wow, it has been.
yeah.
Well, it's good to see you.
It's really good to see you, too.
Yeah, and to hear of Mr. Altman's name. Hadn't heard that name in a long time.
I was surprised. I thought he had actually left, and maybe he came back, or maybe he took a sabbatical.
I don't know. He's the prosecutor that never quits.
That's right. It was really great to see you, Judge Allen.
Great seeing you too. All right, anything else out of order or anything else good? Okay, because wasn't there another attorney back there? Oh, they're together. Okay.
Have a great day.
Okay, how many Spanish cases?
3.
3?
Yes, ma'am.
It's like the magic number, it's 3 every day.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter, and I have been previously sworn.
Good morning, and I'm told we have 3 cases this morning. The first one is Luis Velez Galindo, 2023 CF 2122AO.
Thank you, Your Honor. If you allow me just one moment to connect to the headphones and confirm, please. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Mr. Galindo, the court finds probable cause in your case for aggravated battery with a deadly. Actually, Mr. Interpreter, let me just back up a minute. Would our public defender announce your presence for the record?
Letitia George on behalf of the Office of the Public.
All right, and Ms. George, I do plan on appointing the public defender on every single case this morning unless otherwise noted. Okay? Sir, there's probable cause for count 1, aggravated battery with a deadly weapon and aggravated assault. Bond is set at $5,000 on count 1, $500 on count 2. You are ordered to have no contact with the victim, no return, maintain a separate residence. You're ordered to possess no weapons and no firearms and surrender all weapons or firearms to law enforcement within 24 hours of your release. Also, sir, according to the affidavit that has been submitted, you do not qualify for the services of the public defender. And therefore, you'll need to retain your own private counsel, as I am not appointing the public defender in this case. Do you understand, sir? Oh, guess he does.
Your Honor, for the record, the interpreter did not hear a response from the defendant.
Your Honor?
No, I didn't hear one either. He just got on out of here. We're bringing him back.
Thank you, Your Honor.
Your Honor, I believe the defendant may also need a one-time return to the residence.
Yes, ma'am. Mr. Galindo, I just want to be sure you understand everything that I just said.
Okay.
Does that mean yes or no?
No, no, yo no soy responsable de esos cargos porque esos cargos no, yo no cometí eso, no.
No, I'm not responsible for those charges. I didn't commit that, no.
No, I want to be sure that you understand that I have advised you of what the charges are. I have advised you of your bond. I have advised you of conditions of release. And I've advised you that you don't qualify for a public defender. And so you have to hire your own legal counsel. Do you understand those things?
Okay.
I'm going to take that as a yes. Further, sir, there's one more order I'm going to impose, and that is I will allow you a one-time visit in the presence of law enforcement to recover any personal items or effects, even though I've ordered that you have no contact and not to return, you to get a one-time visit. You understand that?
Gracias, sí.
Thank you, yes.
Thank you too, sir. You may exit. Harold Melendez, case number 2022, I'm sorry, it's 2023 MM 1057AO. Get my glasses up too bad. I'll get them up. Good morning. Sir, I find probable cause for battery, domestic violence, and there appears to be a witness. So, Mr. Interpreter, because we have a witness, we're gonna have to take the headphones off and have this done overhead. Ma'am, raise your right hand to be sworn in.
Do you
Señora, por favor,
solemnly
levante su
swear?
mano derecha para prestar juramento.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Jura solemnemente o afirma. I'm sorry, Your Honor, just for clarification, does this witness require the services of the interpreter?
Yes, we'll clarify. You can take your hand down. Ma'am, you're saying you do not require the interpreter. Speak up, please.
No, I don't.
Okay, no, sir, we can go ahead and put the headphones back on Mr. Melendez at this time. Ma'am, can you tell me what your name is?
My name's Damaris Soto.
Ms. Soto, the state or defense will have questions of you. Please answer the questions just like you're doing now into the microphone, ma'am.
Good morning, Ms. Soto.
Good morning.
How do you know the defendant?
He was my boyfriend.
Do you live together?
Used to. I just moved out.
Okay. While this case is pending, do you want to have any contact with him?
Not at all.
Has something like this happened before?
Not with him.
Were drugs or alcohol involved in this incident?
Yes, he was intoxicated.
Okay, thank you very much. I have no further questions, Your Honor.
All right, thank you very much. Ms. George, I am appointing a public defender. Any questions?
Okay. No questions, Your Honor.
All right, I'm setting a bond in this case. Actually, Mr. Melendez qualifies for pretrial release, so therefore I'm going to order release on pretrial release. Order conditions as follows: that you are ordered to have no contact whatsoever with the victim, not to return to the location this incident occurred, maintain a separate residence from the victim, possess no weapons and no firearms, surrender all weapons or firearms to law enforcement within 24 hours of release. You're authorized a one-time visit in the presence of law enforcement to recover any personal items or belongings.
Your Honor, the victim stated she moved out of the house.
Oh, that's right, ma'am. Just confirming, have you been able to get everything that you need out of the residence?
I think I left some stuff behind. But
I'm sorry, you left some stuff behind. Is it stuff that you need to retrieve or just miscellaneous items?
Just miscellaneous.
So you have no need to go back, is that correct?
I don't want to go back.
Okay, I'm just trying to get a full understanding, because if that's the case, then I'm just going to order to maintain a separate residence, and he will be allowed to return. Do you understand that? To that residence. Do you understand that?
I don't want to return.
I'm sorry, I can't understand what you're saying.
I didn't understand what you said.
Okay, if you moved out, then he can go back. But if you're still living there or need to be there, then I'm going to order him not to return.
No, I'm elsewhere.
You're completely out.
Yes.
Okay, thanks for confirming that. The no return order is deleted, and the one-time or visit with law enforcement is deleted. maintain separate residence is included. Thank you, ma'am. Thank you, sir. The next case is Alexander Eduardo Rojas, 2023 MM 1062AO. Mr. Rojas, is there a witness too? And does this witness need the interpreter? Okay,
Señor, usted va a necesitar los servicios del intérprete.
Sí.
she said yes. Ma'am, raise your right hand to be sworn in.
Señora, por favor, levante su mano derecha para prestar juramento.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Usted jura solemnemente o afirma que el testimonio que usted dará en este caso será la verdad, toda la verdad y solamente la verdad de Dios.
Sí.
Yes.
Ma'am, what is your name?
Señora, me da su nombre, por favor, despacito y en voz alta, por favor.
Mariani Rojas.
Mariani Rojas.
Ms. Rojas, either the state or defense will have questions of you. Please answer their questions into the microphone, just like you're doing now.
Señorita Rojas, es posible que la fiscalía o la defensa tenga preguntas para usted. Por favor, conteste de la manera que está contestando directamente al micrófono.
Okay.
Okay.
Good morning, Ms. Rojas. How do
Buenos
you
días,
know,
señorita Rojas.
how do you know the defendant?
¿Cómo es que usted conoce al acusado?
Es mi hermano.
He's my brother.
Do you live together?
Ustedes conviven.
Sí.
While this case is pending, do you want to continue living together?
Mientras que se esté tramitando este caso, ¿usted aún desea permanecer conviviendo?
Sí.
Yes.
So you also want to continue having contact with him?
Entonces usted desea mantener contacto con él.
Es mi hermano y vivimos juntos.
He's my brother and we live together.
Has something like this happened before?
¿Algo semejante ha sucedido anteriormente?
Lo que pasó es que él estaba bajo sustancias de drogas y tuvo un acto violento contra mí, pero cuando él no está bajo ese efecto no es su actitud.
Well, what happened is that he was under the influence of drugs and he acted violently towards me. But when he's not under the effects of drugs, he doesn't act that way.
I have no further questions. Thank you.
No tengo más preguntas. Muchas gracias.
No questions, Your Honor.
All right, the court orders as follows. With regard to Mr. Rojas, sir, there's probable cause for the charge of battery, domestic violence. You qualify for pretrial release, so I'm ordering you to be released on pretrial release. I'm ordering you to have no contact with the victim.
Apologies, Your Honor. If you could kindly allow the interpreter an opportunity, please.
Oh, I'm sorry, I was going too fast.
No worries, Judge. Thank you. Referente al caso del señor Rojas, determino que existen indicios razonables para el cargo de agresión. Determino que él reúne requisitos para la libertad provisional.
I'm ordering you to have no contact with the victim, not return to the residence, possess no weapons and no firearms,
Ordeno que se le prohíbe el contacto con la presunta víctima, no puede regresar al lugar de los acontecimientos.
and surrender all weapons and firearms in your possession to law enforcement within 24 hours of release.
Se le prohíbe portar armas de fuego, armas blancas y que entregue cualquier arma que porte a las autoridades no más allá de 24 horas de su libertad.
I'm ordering you to consume and possess no illegal drugs without a valid prescription.
Se le prohíbe ingerir o portar drogas que no sean recetadas.
And I'm ordering that you be be randomly monitored for for drug use.
Y ordeno que se le hagan pruebas al azar para el uso de drogas.
Do you understand, sir?
¿Usted me entendió, caballero?
Thank you.
Gracias. And for the record, the interpreter did not hear a reply from the defendant.
Well, the public defender seemed to shake her head, but I'll just go ahead on and let's hear a reply from either the public defender or the defendant. Somebody needs to
Por favor,
respond.
que responda el defensor público o el acusado a esa pregunta.
Your Honor, what I was going to ask for was, since we're having the random drug screens and the victim stated that it's the drugs that is an issue. If he's on pretrial release being monitored and randomly drug screened.
Hold on.
Su señoría, ya que usted ha pedido pruebas de drogas al azar y la víctima ha indicado que esto sucedió bajo los efectos de drogas y él va a ser monitoreado por el Departamento de Libertad Provisional,
That he be allowed to return to the residence, and if he violates any of the conditions, he can be brought back and held at no bond.
y si se le permite regresar al lugar de los acontecimientos y si él incumple esas condiciones, que sea regresado aquí a la cárcel sin derecho a fianza.
I would be happy to allow him to go back home, but I heard equivocation from the victim. I need the victim to say with certainty if they want the person to have contact with them or not.
Y yo estuviera dispuesta a permitirle que regrese, pero por parte de la víctima no escuché determinadamente que ella desea que él regrese a la casa y por lo tanto se lo tengo que prohibir.
Do you wish to inquire?
Licenciado, usted desea preguntar.
Yes, Your Honor.
Sí, su señoría.
If Mr. Rojas is randomly drug screened, would you feel comfortable if he returned to the residence?
El señor Rojas le hacen pruebas de drogas al azar. ¿Usted se sentiría cómoda de que él regrese al hogar?
Sí.
Yes.
Does the state wish to follow up?
La fiscalía quiere darle seguimiento.
No, Your Honor.
No, su señoría.
All right, Ms. George, I'm going to grant your request,
Licenciada George, voy a concederle su pedimento.
and I will order that the defendant have no hostile contact with the victim.
Voy a ordenarle al acusado la prohibición de contacto hostil con la víctima.
Thank you, ma'am, and thank you, sir.
Your
Gracias,
Honor,
señorita. Gracias, caballero.
just for clarification then, are you striking the no return?
Yes, ma'am. I am I'm deleting it. I don't have to strike it because it was never actually written. Deleting that, so we're not going to order that. Just
Señoría, para aclarar, usted está
hold him. Just for for my own personal clarification. Let me just do the whole thing all over
Entonces, usted
again.
me está diciendo de que va a anular la condición de prohibición de regresar. Sí, basado en lo que me acabo de decir.
I'm ordering you to be released on the pretrial release program.
Le voy a ordenar su libertad bajo el programa de libertad provisional.
You have no hostile contact with the victim.
Se le prohíbe contacto hostil con la víctima.
You are subject to random drug monitoring,
Será sometido a pruebas de drogas al azar.
and you're ordered to consume no illegal drugs without a valid prescription.
No se le permite ingerir drogas ilícitas y drogas que no sean recetadas.
You're ordered to possess no weapons and no firearms,
Se le prohíbe portar armas de fuego, armas blancas.
and you're ordered to surrender all weapons and firearms in your possession to law enforcement within 24 hours of release.
Cualquier arma que porte se le exige entregarlas a las autoridades no más allá de 24 horas después de su libertad.
Do you understand?
¿Me entendió usted?
Yes.
Thank you.
Gracias.
Is that it for Spanish? Thank you, Mr. Interpreter.
You're welcome, Your Honor. Have a good morning.
You do the same, Mr. Interpreter. Okay, what is this? State, as to Mr. Blue, the court reviewed the statute, and is Mr. Blue, is this Mr. Blue? Yes? I'm sorry, I don't.
He said yes, ma'am.
Oh, okay. So I'm not going to need to read the additional information after looking at the statute itself. The court does find probable cause for the charge of attempted second-degree murder, and bond will stay set at no bond.
Your Honor, he's entitled to a bond.
Bond will stay set at no bond. The court will order that the defendant have no contact with the victim, not return to the location where this incident occurred, possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. The court disagrees with the defense. I am setting no bond. And if the state agrees with the defense, I disagree with the state too. I'm setting no bond.
For the record, the defendant is entitled to a bond, Your Honor, as it's.
And as I said, I disagree. Based on the facts of this case, no bond.
Understood, Your Honor. There was also a witness. Can I also ask for no contact with the witness?
Yes, the court will also order no contact with the witness that was involved in this incident as well.
And Your Honor, I'm just gonna object on the record. The defendant is entitled to a bond. It's not a crime punishable by life in prison.
Are you taking any,
Your objection's noted.
are you taking any action on his out on ROR case, Your Honor?
Yes, the court is revoking ROR and setting no bond. Deshaun Schnell. There is a need for a sign interpreter, but Madam Clerk, 11 o'clock? Okay. We will be recalling this case. I can assure you we will not be in here at 11 o'clock because we're going to be finished before then. So we're going to have to make arrangements some other kind of way. Juan Antonio Aguilar. Mr. Aguilar, you were picked up on an out-of-county warrant from Escambia County, and bond's gonna stay set at no bond on this case, sir. But, oh, actually, this is the case that I needed additional information on. This is the case, gosh, you look different from yesterday to today.
Yeah, I finally got a hair tie. If you want, I could take it off. I have my.
No, I see it's you now. Yesterday,
Yeah, I was looking like a lion.
no, you looked good, and today you just look like a different person.
Yeah.
State, in this case, were you able to find out from probation if he's being supervised locally here in Orlando?
I apologize, Your Honor, that wasn't the research that was done.
What was done?
The research that was done was to contact Escambia County, where it was determined that that was the jurisdiction. There's a state attorney there that we spoke to that confirmed the violation of probation is in Escambia County. The judge acknowledged that she set the bond at 0 bond. That's what we were able to determine, Your Honor.
Well, that's fine. That means that this Escambia County is supervising him and wants this case back. At least that's what I think you're saying, as opposed to Orange County.
It is not an Orange County case, Your Honor.
Okay, well, who did you communicate with? Escambia County?
Yes, Your Honor.
Okay. Did you find out anything different, Ms. George?
No, Your Honor. We couldn't get any access to anything.
So you just didn't even find anything out?
I spoke with my supervisor. She said there's nothing we can look at. We can't see the case. We can't even.
You didn't find anything out? Is that a yes or a no?
Oh, yes, Your Honor. We found nothing. I didn't find anything out. Correct.
Okay. Sir,
Your Honor, may I speak about the case?
you can say whatever you want to say.
All right, perfect. I'm here because I have a violation of probation on a misdemeanor of a resisting arrest without violence. It's technical violations. My probation officer told me that I didn't let him know about my change of address when I had spoke to him, and I let him know that I was homeless at the time. That by the time that my next meeting came up, I was gonna give him a call and give him my address. And when I gave him a call that's recorded online with the Department of Corrections, I called him and I let him know my address.
Why would that be recorded on with the Department of Corrections if this is a misdemeanor probation?
Oh, I'm sorry. I meant when I called the probation office and I spoke to him on the phone. I'm pretty sure those phone calls are recorded. And I spoke and I said that this is my address, 5962 Westgate Drive, apartment 202. And then he said, okay, perfect. I'll see you when you come in, right? So then I'm coming into probation. Everything's fine. I wrote down my address. And then when I get there, I sit down and then they arrest me, telling me that I violated my probation. And then the probation officer told me that I told him that I was living at Westgate. And because maybe he didn't hear me right on the phone, but I explained that I was living in Westgate Drive, and it's recorded on the phone call.
So I don't know about recording, but let me just tell you about processes. How processes work is this. People have to initiate actions based upon what people think are important. In your case, sir, it is a misdemeanor. You say you are being supervised by Orange County. Miss Eugene is the prosecutor, and she followed up on that to the best of her ability, it seems. The information that she has received, while seemingly reluctantly given to me, would indicate that you're being supervised by Escambia County. Hold on a minute. I can follow up on that. And if I think that I have been told something that's improper, a procedure is in place for me to take care of that. But you don't have to worry about that. The question is do I feel like I need to follow up on it? I don't believe I have to follow up on it. I doubt if the state would come into this courtroom and tell me something that is improper, incorrect, or untrue. If she uttered it out of her mouth, it better be proper, correct, and true. I think what she said to me is proper, correct, and true. Therefore, there's nothing else for me to do in this process. And I could assure you that if I thought that there was, I would follow it. Now, hold on, because I know this is troubling to you. Yesterday, all I was concerned about was whether or not somehow this case was really an Orange County case. I'm not hearing that. I'm hearing that this is definitely an Escambia County case. Am I correct, Ms. Prosecutor?
Yes, Your Honor, but I would like to clarify one thing. What I said was Escambia County has jurisdiction in this case.
But you said you spoke with Escambia County about it.
Yes, and they have jurisdiction. Your Honor, we're saying two different things because Escambia County does have jurisdiction and he should be returned to Escambia County. I didn't speak to...
What do you mean we're saying two different things? That's what I'm saying.
Your Honor, when you say that he's being supervised by Orange County, he may well be. But because this offense happened in Escambia County, he is to be returned to Escambia County.
That's what my understanding is. That's what you said, right?
Yes, Your Honor.
And that is what I'm confirming.
Yes, Your Honor.
We have no question here that Orange County does not have this case.
No, Your Honor.
So, sir, that's it. The processes that were in place have been complied with by the state. Where does that leave you? It leaves you in jail on a no-bond warrant unless the judge in Escambia County is convinced to give you a bond. And that is entirely up to the judge in Escambia County. Of course, the state could drop the charge too, but apparently the state is moving forward. She's had communication with either the state or the probation office, I forget which one, but you've had communication with Escambia County,
Yes,
right?
Your Honor.
Sir, processes have been followed. Once processes are followed, I'm convinced there's nothing else that I can do. I mean, there's always different things that we can do, but if processes are followed, I'm not going to create new processes just to do new things. But I am sorry that you have to be in jail on a no-bond warrant on a misdemeanor that you were supervised in Orange County for, thinking that Orange County would quickly set this and you could resolve it in Orange County, because you cannot. It will have to be resolved in Escambia County. From what I've been told this morning, I have no reason to question what I was told this morning. But you tried. And the prosecutor followed my order from yesterday, and they got me information today, and I am satisfied. So you will be held until Escambia County decides to pick you up. If you can get an attorney to handle your case in Escambia County and go before the judge in Escambia County, that's probably your best course of action if you want to get out of jail or get a bond before Escambia arrives in Orange County to pick you up.
I have a quick question, Your
Go
Honor.
ahead.
So, since the jurisdiction lies in Escambia County, and then I was being supervised here in Orange County, right? For me to initiate that process of moving the case from Escambia.
You don't have to do a thing. You don't have to initiate a thing. So the prosecutor confirmed to me that this case was never transferred to Orange County for Orange County to have any jurisdiction over the case. It was solely transferred to Orange County for Orange County to supervise your probation. And a lot of times that probation, when I do it, I'm gonna tell you, when I do it and I keep the case, but it's by phone in or mail-in status. So that means that if I send a case to Escambia County, I'm still the judge on that case. Even though I let the person move to Escambia County, I'm allowing that person to live where it's comfortable for them to live, but they have supervision in Orange County via phone in or mail-in status. So it makes sense to me that something similar, I don't know the exact details, but I think I know enough. And all I'm telling you is procedures have been followed. Once procedures are followed, my only question is, do I feel like I'm being told the best information? And I already answered that. I think I'm being told the best information. The only other thing I could do is literally contact the judge myself, but that's creating a new procedure that I am not going to create. But I do think you deserve for us to look into it based on what you said yesterday. So we looked into it. She has brought to me, the best information that I think I'm gonna get on this today. And I am satisfied. I'm trying to hope that you will be satisfied, but even if you aren't, it's too bad because I'm satisfied and I can't take it any further. The last thing I want is for people to leave here and feel like they were not considered as a human being, but just as a number, just somebody who got arrested and who cares about them. Well, I'm gonna tell you one thing. That prosecutor followed up just like I asked. It was a different prosecutor yesterday, but they passed the information to each other. I got the answer I needed this morning. Do you understand that I'm satisfied with the answer I received?
Yes.
Okay, so I want you to be satisfied, even if you're unhappy because you know you're gonna be stuck in jail for a little while. But somebody cared enough to look into what you said, and it was your prosecutor. And the prosecutor is charged with prosecuting you, yet they took the time out of their busy day, called Escambia County, got on the phone with them, communicated with them, got an answer from them, brought that answer back to me in court this morning. I have no doubt, and I've told you, she wouldn't come in here and tell me something that's inappropriate.
I understand.
So where does that leave you? Where does it leave you? In jail with the no bond warrant.
And just one more quick question.
No more quick questions.
Okay, well, I have
You've had all the quick questions you're gonna get today. But sir, good luck to you, and I hope it works out for you in Escambia County.
All right, thank you, Your Honor.
Bye. Thank you, Miss Eugene, I appreciate that. And I felt like you were telling me what I think, I'm trying to explain to him so he feels like he's not just a number in a box.
Understood, Your Honor, thank you.
As a matter of fact, I really do appreciate what you did. I do, I really, really do. You and Miss
Fleming, I will
Fleming.
pass that on, Your Honor.
Yeah, I really do appreciate that. Somebody did it other than me. Because if you guys didn't do it, that means I would have to do it, so thank you.
Understood.
Sometimes you may think, well, why is she saying it the way she's saying it? Well, it's because of him. I want him to understand. I would, hammer if I felt like somebody wasn't doing what I asked them to do or did something inappropriate. I thank you for doing it, okay? And I thank Ms. Fleming. And he should be happy. And if he's not, well, we tried, didn't we?
Yes, we did.
We tried. We can't always give everyone the answer they want to hear.
That's true.
So I would have been happy to give him a bond or something if for some reason this whole entire case came to Orange County and it wound up being a Division 85 case. Or I would have been happy to email one of my judge friends and say, hey, I have your case. This guy's no bond on a resisting. Do you want me to give him a bond? And see what they said. But that's not the information we found out. So we have to live with that. And I'm okay with that. But I just don't want you to feel like in any way that I was misunderstanding you. I completely understood.
okay.
I was just, sometimes I say things differently, but it's not for your benefit. It's for his benefit. Or someone else's benefit that might be in the courtroom. But it was not for your benefit.
All right. Thank you, Your Honor.
Okay, you're welcome. And my bark is far much worse than my bite, by the way.
I disagree, but okay.
My bite is horrible. Okay, thank you for following up on that. I really do appreciate that. I don't like treating people as a number. I just don't. William Baston.
He's mental health.
I will waive.
All right, so his defense attorney is waiving, and yes, I am appointing the public defender in this case. There is probable cause based on a PC warrant. Court sets a bond of $1,000, and defendant is ordered to comply with all reporting conditions within 24 hours of release. Thank you.
I think he has two cases, Your Honor.
Let me see.
You also see a resisting without.
Let me
Then
see.
He also is out on bond as
Yeah,
well.
I got it. And the court will look at that one quickly since I don't know if I saw it this morning. Yes, the court finds probable cause for the charge of resisting an officer without violence. Bond stays at $500 on that charge. You said there's an out on bond case?
He is, he's out on bond. It's,
No, I don't even have that. No, okay, some of this some of it is my fault and some of it is I don't have stuff.
yeah, it was a couple days old, him being in here, but it's.
It's a lot of paperwork.
He's out on bond. It's a failure to report, in 2022 CF 00509.
Another failure to report?
It's another failure to report, Your Honor, yes.
All right, let me see. And state you filed on that one?
It has been filed on, Your Honor. However, there is a status set for February 21st. It looks as though they are trying to resolve it. So at this time, the state would have no objection to no action being.
All right, I'll take no action on that out on bond matter. Darius Brunson?
Yes.
Mr. Brunson, and the court finds probable cause for obstructing justice by intimidating or threatening a witness, and bond is set to $2,500. Battery, oh, actually, there's a witness. Raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, ma'am, can you tell us what your name is?
Cheyenne Baker.
Speak up, ma'am.
Cheyenne Baker.
Ms. Davis? All right, Ms. Davis, either the state or defense.
Sorry. Last name is Baker.
Baker?
Yes.
Yes, ma'am, sometimes with all of everything going on, I'm a little hard of hearing. I'm gonna need you to speak into the microphone as best you can, okay?
Okay.
All right. Either state or defense will have questions of you. You do need to answer the questions into the microphone as I asked.
Good morning, Ms. Baker.
Good morning.
How do you know the defendant?
It's my ex-boyfriend.
Do you live together?
Yes.
While this case is pending, do you want to continue living together?
I don't want to press any charges, but I don't want any contact.
Okay. And please correct me if I'm wrong. As you said, no contact. You do not want to live together any further, any longer, and you don't want contact outside of the home either. Is that correct?
Right.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No.
I have no further questions. Thank you very much.
Defense?
And are you still residing at the residence?
I am.
Okay. No further questions, Your Honor.
I didn't hear the response to that last question.
Yes, I am.
All right, the court orders a bond of 2,500 on count 1, 500 on count 2, because I do find probable cause for both counts. I am ordering you to have no contact whatsoever with the victim, no return with the exception of a one-time visit in the presence of law enforcement to recover personal items. And finally, I am ordering that you possess no weapons and no firearms and surrender all weapons and firearms to law enforcement within 24 hours of your release. Ma'am, thank you. Rayshawn Cartagena. Mr. Cartagena, in your case, I find probable cause for aggravated assault with a deadly weapon. Bond is set at $2,500. Further, I'm finding probable cause for assault. Bond is set at $500. You're ordered to have no contact with the victim, not to return, with the exception of a one-time visit in the presence of law enforcement to recover personal items, possess no weapons, possess no firearms, and surrender all weapons and firearms to law enforcement within 24 hours of your release. Thank you. Sharisa Drew. Mental health.
I will waive.
All right, Drew's presence is waived. Sorry about that. Court sets, finds probable cause and sets a bond of $3,500, revoking bond on the out on bond case and setting, no bond. Byron Mendez.
Your Honor, before you move on, can you do the conditions on Ms. Drew's?
Oh, yeah, sorry. I moved so fast. Is there a witness on this case or a previous case? Sorry, I didn't even look up.
I believe.
Mendez, are you here for the Mendez case? Okay, that's the current case. Let me hold the paperwork on the prior case. As to Drew, the court is ordering no contact with the victim, no return, possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release.
Could she have a one-time return with law enforcement?
Yes, a one-time return in the presence of law enforcement to recover personal items is ordered. Now, ma'am, raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Ma'am, can you tell me what your name is?
Emily Galindo.
Galindo?
Yes.
Ms. Galindo, either the state or defense will have questions of you, and they'll ask you questions, and you need to answer as best you can in that microphone, okay?
Okay.
State.
Good morning, ma'am. How do you know the defendant?
He's my boyfriend.
While this case is pending, do you want to continue living with him?
Yes.
I apologize for this question. There's an indication that you were pregnant.
Yes, I am.
Is Mr. Mendez aware of your pregnancy?
Yes, he did. He knows.
And how is he aware?
I told him.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
Yes.
Can you tell me which one?
He was drunk.
I have no further
What was
questions.
the response to that last question?
The witness stated that he was drunk, Your Honor.
Okay.
I have no further questions, Your Honor.
Defense.
No, no questions, Your Honor. I am going to challenge PC as to the pregnancy. Based on the affidavit, there's no indication that he knew or should have known she was pregnant. It alleges that she was 4 weeks pregnant. So I would argue no PC as the aggravated battery on the pregnant person.
What says the state?
Your Honor, sworn testimony was elicited today that the victim is pregnant and that the defendant knew as he had been told.
Okay, the court does find probable cause for this offense. And I am setting a bond of $3,500.
And I would object, Your Honor, because it's not in the affidavit. It's not in the 4 corners of the affidavit as far as PC.
Well, obviously, I have not sustained your argument because I have heard everything I needed to hear. I did hear from the witness, and the officer did write in the affidavit that the victim was pregnant at the time. Of course, we do wish the officer would write a whole novel about this incident, but given the time constraints, the officer indicated that there was a pregnancy and there was a battery. I am ordering a $3,500 bond. And I am ordering no hostile contact. State, just remind me with everything going on, she did say she wanted contact.
That is correct, Your Honor.
No hostile contact. I'm ordering possess no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of your release from incarceration. Thank you, ma'am, and thank you, sir. Did I give you the right paperwork?
Yes, ma'am.
Mendoza. What, Jason Jacob Mendoza. And ma'am, raise your right hand to be sworn in.
Do you solemnly swear or affirm the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. What is your name?
Jasmine Valdez.
Valdez. Ms. Valdez, either the state or defense may have questions of you regarding this case. Please answer their questions into the microphone, ma'am, okay?
Okay.
Good morning, Ms. Valdez.
Hey.
How do you know the defendant?
He was my boyfriend.
Would you like to adjust the microphone?
He was my boyfriend.
Do you live together?
No.
While this case is pending, do you want to have any contact with him?
No.
Has something like this happened before?
Yes.
Apart from yesterday, when was the last incident?
It was last year.
Were drugs or alcohol involved in this incident?
No.
I have no further questions. Thank you for coming in.
No question from the fence.
Thank you, ma'am. The court finds probable cause for count 1, aggravated battery with great bodily harm. Bond is set at $3,500. Count 2, battery and dating violence. Bond is set at $500. You're ordered to have no contact whatsoever with the victim. Maintain a separate residence from the victim. You're ordered to possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of your release. April Mullings. In your case, ma'am, you were picked up on a PC warrant for aggravated assault, domestic violence, and the court finds probable cause and sets a bond of $2,500 with the following conditions: that you have no contact with the victim, not return to the location this incident occurred, possess no weapons or firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release, that you possess and consume no drugs or alcohol. You are subject to random drug and alcohol monitoring through pretrial release. The first monitoring, the court is ordering to occur within 72 hours, and all future monitoring shall be randomly scheduled. Further, ma'am, I am allowing, if needed, a one-time visit in the presence of law enforcement to recover personal items. Thank you. Javon Kandaya.
Daya is mental health.
I'll waive.
Defense counsel is waiving. Court finds probable cause for violation of a domestic injunction by contacting the victim. Bond is set at $500. No contact, no return. Possess no weapons, no firearms. Surrender all weapons or firearms to law enforcement. Comply with all terms of the injunction. The court is revoking the bond on the battery and setting no bond. Juan Piero Laster. The court finds probable cause for battery, domestic violence, and orders a bond of $500. I am ordering you to have no contact with the victim, maintain a separate residence from the victim. I am ordering that you possess no weapons and no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of your release from incarceration.
Yes, ma'am.
Thank you. Lee Nikki McLaughlin Allison. As to your charge of battery, domestic violence, I do find probable cause, and I am setting a bond of $500. I'm ordering you to have no contact. Actually, you do qualify for pretrial release, and so I'm gonna, instead of setting a bond, order you to be released on pretrial release. And I am ordering as a condition of pretrial release that you have no contact with the victim, that you possess no weapons, no firearms, surrender all weapons and firearms in your possession to law enforcement within 24 hours of a release. You are authorized a one-time visit in the presence of law enforcement to recover personal items. Thank you, sir. Taylor Safford.
Taylor Stafford is mental health.
Unless defense wishes to waive, the court does find probable cause in this case, and bond is set at $500. No contact, no return, one-time visit if necessary in the presence of law enforcement to recover personal items, no weapons, no firearms, and surrender all weapons or firearms to law enforcement within 24 hours of release. Samuel Steele. Mr. Steele, in your case, I do find probable cause for battery, dating violence. I am ordering that you be released on the pretrial release program. As a condition of pretrial release, you are ordered to possess no weapons and no firearms, surrender all weapons and firearms to law enforcement within 24 hours of your release. You're ordered further, sir, to have no contact with the victim and not return to the location. You are authorized a one-time visit with law enforcement to recover personal items. Thank you. Devontae Anderson.
Step up to the microphone.
Devontae Anderson, you were picked up on an out-of-county warrant from Brevard County. Bond will stay set at $100,000 on count 1, $5,000 on count 2, and $1,000 on count 3 until you are picked up from that county or you post bond. Thank you. Carisha Cologne. Ms. Cologne, ma'am, in your case, you were picked up on an out-of-county warrant from Polk County, 3 counts, and bond will stay at no bond on all 3 counts. Thank you, ma'am. Which other affidavit? Oh, the one that I sat down on the wrong side? I'm trying to multitask up here. Y'all know my brain is going, okay, it's that way, this way, this way, this way, this way.
You're doing good.
I'm like an octopus with tentacles going out everywhere from my brain to the clerk, the prosecutor, the public defender, the defendant, forgot about that, and the PTR and witness in the witness box.
You're doing good.
I feel like I'm doing bad. I need the positive reinforcement. Thank y'all. Thank you for the positive reinforcement. This is not easy. Multitasking. Jessica Jones. Okay. All right, defendant was picked up from Seminole on a Seminole out-of-county warrant, and bond's gonna stay at no bond in that case. Scott Stencil. Waive or, all right, picked up on an out-of-county warrant, Lake County bond was set at 2,000 and will stay at 2,000. No. Melissa Bauer. All right, as to this violation of probation, the defendant's bond will stay at $500. Jordan Charles. Mr. Charles, you were picked up for violating your probation for changing your residence without permission. Bond will stay at no bond. Thank you. Zevin Clay. Zevin Clay. Are you Zevin Clay? All right, Mr. Clay, you were picked up for a violation of your probation condition 5 for committing a new law violation of loitering and prowling. Bond will stay set at no bond. Thank you, Mr. Clay. Michaela Dyer. Ms. Dyer, you were picked up for violating your probation for failure to pay fines and costs, failure to pay costs of supervision, and failure to complete community service. Bond will stay at no bond in that charge. Thank you, ma'am. Alberto Rojas.
Yes, Your Honor.
Mr. Rojas, you were picked up for violation of community control for failure to remain confined in an approved residence without prior approval of your probation officer, and there were 3 counts of that, all on different dates and times. Bond will stay at no bond. Thank you. Victor Toro, you're picked up also for violation of community control, condition 1, or condition L, by reporting a new law violation involving marijuana use to your probation officer, and failure to complete a substance abuse treatment program. Bond will stay at no bond. Thank you, sir. Micah Hall. Defendant was picked up for violation of probation, and bond's going to stay at no bond. Okay, sign interpreter case involving Dashanell Snell. Has the interpreter arrived yet by any chance? If not, we'll pass that. Anything else for this morning that I can handle right now? Okay. Miss Eugene, there comes a time when I want to rest my vocal cords. Now is that time.
Are you ready, Your Honor?
I'm
I can go
ready.
through.
Yes, I'm ready, ma'am.
Nathaniel Smith, 23 CF 919, granted notice of non-filing.
All right, granted.
Douglas Lee Martin, 23 CF 605, denied, information was filed.
This will be denied.
Willie Celestine, 23 CF 654, granted, notice of non-filing.
That will be granted.
Byron Louder, 23 CF 150, denied, information was filed.
It's denied.
Rolando Villavicencio, 23 CF 674, denied, information was filed.
That's denied.
Camilo Enrique Fernandez Lopez, 23 CF 354, granted, notice of non-filing.
Right, this motion's granted.
Demarion Rucker, 22 CF 12939, granted, notice of non-filing.
That's, they didn't give me, well, you said granted, right?
Yes, Your Honor.
Madam Clerk, court will stand in recess for 1 hour, which puts us at 11:30. Isha Francis McDuffie, 23 MM 848 AO, state does not oppose, so therefore the court is granting this motion. Anything else, Madam Clerk? I'm going to recess again. Wait, location 2. No. Well, then we're trying to get you out of here. You are busy. You're very busy. Yes, indeed. Well, we're back on the record. The assigned interpreter has arrived. We're just awaiting the public defender to come back into the hearing room, into the courtroom.
I'm calling now. I sent her a text, but I'm just gonna call her now. I do not. Can you put that in the shred pile? Thank you so much. Hey, I didn't want to do the text message, but the sign interpreter. Okay. Bye. Okay, thanks. She's on her way, Your Honor.
Thank you.
Yes, ma'am.
And Deputy, is the defendant Dashanell Snell being prepared to come into the courtroom?
Yes.
Richard Hornsby? Yes, if the lawyer is asking to do that, it's fine with me. But I'll still need to see the defendant to let him know that I'm resetting it. Yes, just make sure you put a note on it so that I don't go doing the probable cause if I find probable cause without his attorney being present. I'm just gonna let him know his attorney has requested to reset that and give the state the name of the defendant as well, please. Jasmine. Yes. Well, I don't pronounce Sharon. So, hey, there you go, you have it. But actually, I do. I love unusual pronunciations. I absolutely love it. Names are my thing. So I have to tell you a little bit of a story about names. It seems that everyone's back in place now. We are on the record in the case of Dashawn Snell. A language interpreter is present, a sign interpreter, sorry, who has previously been sworn. State and defense are present. Mr. Dashawn Snell, in your case, the court does find probable cause. I find probable cause for the charge of a battery, domestic violence. I gave my PTR paperwork back to you, Ms. PTR. Don't recall whether he qualifies or
He
not.
does qualify, Your Honor.
You qualify for the pretrial release program, and so I am ordering you to be released on pretrial release with the following conditions. You are ordered to have no contact with the victim. You are ordered to not return to the location this incident occurred. I will go ahead and look at the interpreter. I will allow a one-time visit in the presence of law enforcement to recover any personal items that you may need. You're also ordered to to surrender any weapons or firearms to law enforcement within 24 hours of release and possess no weapons and no firearms. I am also appointing the public defender to represent you in this case. Is there anything else from either the state or defense?
Based on the pretrial services paperwork, they stated that the victim's mother picked her up last night and brought her to Palm Beach. Could we do a maintain separate residence and a one-time return, Your Honor? And if the victim is there, then he can't reside there. But based on what was told to pretrial services, the victim is not residing at the residence at this time.
What says the state?
I don't have that information, Your Honor, but, no, I don't have that. But I would have no objection if that is what has been stated.
Sir, I am ordering that you maintain a separate residence from the victim. You are ordered or allowed a one-time visit to recover personal items and effects. You are only authorized to remain at the residence if the victim has left the residence. And I will delete the no return provision. Do you understand? Go ahead.
I'm wondering if the victim is not at the home and I have the house key, so am I allowed them to go into the home?
The answer to that question is yes, as long as the victim is not at the home. But to clarify, if the victim is at the home, you must only pick up your personal items in the presence of law enforcement, and then you must leave, because I am ordering you to maintain a separate residence. However, if the victim has already relocated to somewhere else, that means you can stay there if she is not there. Thank you. All right, that concludes this hearing. This matter is over. We are in recess again.
1 second while I connect.
Oh, we're doing it over the loudspeaker there.
You're doing over the, okay, it's an IA.
Yes.
Very well. Edward de Jesús, por favor.
And counsel, can you see us yet?
Yes, Your Honor, we can now.
Okay, great. Good afternoon, Mr. Blanche de Jesus. Can you hear me?
Buenas tardes, señor Blanche de Jesús. ¿Me escucha? Yes.
All right. Sir, in this case, you were picked up, it looks like for a violation of probation out of Palm Beach County, Florida.
En este caso, usted fue detenido aparentemente por una violación de probatoria del condado de Palm Beach.
And also charged with petty theft, possession of a controlled substance without a prescription, and possession or use of drug paraphernalia.
Y fue por posesión de parafernalia, posesión de droga para uso y punto menor.
And I see that you cannot afford an attorney, is that correct?
Y veo aquí que usted no puede pagar un abogado, ¿eso es correcto? I'm sorry, counsel, you need to unmute the microphone when he answers.
My phone is muted, Your Honor.
We could not hear him.
Let's see. Okay.
No, I can't.
We can hear you now. All right. Then I'm going to appoint the Public Defender's Office to represent you, sir.
Muy bien, pues estoy nombrando a la oficina del defensor público para que lo represente.
I do
Okay.
find that there is probable cause in this case.
Estoy determinando que hay causa probable en este caso.
Bond has already been set, it appears, on the petty theft or retail theft at $250.
Aparentemente ya se estableció una fianza para el caso de hurto menor, hurto en comercio, de $250.
On count 2, possession of a controlled substance, bond is set at $1,500.
En el caso número 2, que es posesión de sustancia controlada, son $1,500.
And count 3, the possession of drug paraphernalia, bond is set at $250.
Y en el cargo número 3, que es posesión de parafernalia de droga, la fianza son $250.
But as to the violation of probation, we'll hold it 0 bond and you'll be transported by Palm Beach County.
Pero debido a que hay un cargo de violación de probatoria, eso es 0 fianza, por lo tanto usted va a permanecer detenido hasta que lo transporten al condado de Palm Beach.
Okay. Thank you, sir. You can have a seat.
Así que eso es todo, se puede sentar.
Next court date on demand.
Apologize for the interruption. Landry Balance for the state. Your Honor, as to the new law violation, the state would respectfully request as conditions of pretrial release, no return to that Walmart store where he to bond out, as well as no alcohol or drugs without a prescription.
Okay. Those
En cuanto a las condiciones de libertad, se están solicitando de parte de la Fiscalía que no pueda regresar al Walmart donde se cometió la violación y que no pueda poseer ni drogas ni sustancias controladas durante el tiempo que esté en libertad bajo fianza.
And those conditions will be imposed.
Esas condiciones se van a imponer.
Thank you, Your Honor.
Our next case is 2023 CF 510 and 2023 MM 379 State versus Leandro Camacho Tapia.
No, I do have a PCR with this case.
Okay. Good afternoon, Mr. Camacho Tapia. Can you hear me?
Buenas tardes, señor Camacho Tapia. ¿Me escucha?
Sí.
Yes.
And in your case, are you asking to have the Public Defender's Office represent you today?
Para el caso suyo, ¿usted está pidiendo que lo represente el defensor público?
Sí.
Yes.
So I will appoint the Public Defender's Office to represent you today, sir, on a provisional basis.
Muy bien, voy a nombrarle a la oficina del defensor público para que lo represente hoy de forma provisional.
And in count 1, sir, you have been charged with resisting an officer without violence.
En el cargo número 1, usted está acusado de resistir a un oficial sin violencia.
And that's in case number 2023 CF 510.
Y ese es el caso 23 CF 510.
I take that back. That is in case number 2023 MM 379.
Perdóneme, es en el caso 23 MM 379.
In case number 2023 CF 510, you've been charged with your second DeWillis, which is driving while license suspended.
En el caso 23 CF 510, usted está acusando de un segundo evento de manejar sin licencia.
And counsel, you said that you had an argument to make as to probable cause?
Yes, Your Honor, just for the resisting officer without violence charge.
Tenemos un argumento para hacer de causa probable en cuanto al cargo de resistir sin violencia.
Your Honor, my argument has to the resisting officer without violence charge, that there's no indication, if the resisting was the running from the officer, Your Honor, there's no indication that there was any order to stop.
La alegación de resistir sin violencia fue porque él corrió y aparentemente no hay ninguna evidencia de que se le haya dado una orden de que parara.
Or any indication that there was an order to remain where he was in any case.
Ni que hubiera ninguna orden de que él tenía que permanecer donde estaba.
In addition, Your Honor, if the resisting occurred when after the takedown was, if the resisting supposedly occurred after the takedown, Your Honor, the officer indicates that my client locked up his arms underneath his chest. I believe it's just as likely that he had just been body slammed to the ground and his arms landed underneath of him.
Y también si el argumento es de que la resistencia fue después de que fue parado, entonces la alegación que hace el policía es de que él trancó los brazos debajo del pecho mientras estaba en el suelo y es muy probable que sencillamente él haya caído sobre sus brazos en esa posición. aparte del hecho de que se hace difícil creer que una persona pueda trancar sus brazos debajo del pecho cuando alegadamente tienen otra persona acabando de tumbarlo al suelo.
Thank you, Your Honor.
State.
Your Honor, the point of today's hearing is to determine whether there is probable cause just based on what is in the affidavit alone. And
El
given
punto
that
de
the
hoy, su
officer-
señoría, es determinar si hay causa probable basado en lo que existe en la declaración jurada solamente.
The officer says that the defendant tensed up his arms and was locking them under his chest. Whether or not that actually happened is not what we're here for today.
El
Simply a
oficial
probable
indica
cause
que
determination.
el oficial indica que el acusado trancó sus brazos debajo del pecho mientras estaba en el suelo y eso es sencillamente la alegación. No estamos aquí para determinar la veracidad de esa alegación el día de hoy.
The affidavit says in part, I approached Leandro to place him under arrest, but Leandro ran away from me toward the garage. Further on, it says,
La alegación dice en la declaración jurada que yo me acerqué a Leandro para ponerlo bajo arresto y Leandro corrió hacia el garaje.
Leandro was resisting by tensing up his arms and locking them under his chest.
Y Leandro puso resistencia al tensar sus brazos y colocarlos debajo del pecho.
Your Honor, there's a sufficient basis based on this affidavit alone to find probable cause for resisting an officer without violence.
Basado en esta alegación solamente de esta declaración jurada, hay suficiente evidencia para una determinación de causa probable para resistencia sin violencia.
Anything else from the defense?
I would just say, Your Honor, just because an officer says that the crime occurred doesn't mean that that's probable cause. The officer can't just say he was resisting, therefore he was resisting.
Yo quisiera decir que solamente por el hecho de que un oficial diga de que él estaba llevando a cabo cierta acción no quiere decir que estaba llevando a cabo esa cierta acción. El hecho de que él dice que él puso resistencia no significa que él haya puesto resistencia.
Well, I think that it turns on a factual issue of whether by tensing up and he was locking his arms under his chest or if he was unable to move his arms from under his chest. But either way, I think there's enough to establish probable cause and do find that probable cause exists.
Muy bien, yo creo que es un asunto de hechos y de evidencia el hecho de si él estaba tensando o tenía los brazos trancados debajo del pecho mientras estaban tratando de colocarlo bajo arresto. Y yo entiendo que con la evidencia o la alegación que aparece en la declaración jurada es suficiente evidencia para una determinación de causa probable.
And as to case number 2023 CF 510, driving while license suspended, a second or subsequent offense, I'm setting bond at $2,000. And in case number...
En cuanto al cargo del 23CF510, que es un segundo evento con licencia suspendida, estoy poniendo una fianza de $2,000.
And in case number 2023 MM379, the charge of resisting an officer without violence, the court sets bond at $500.
Y para el cargo del 23MM379, que es la resistencia a un oficial sin violencia, la fianza va a ser... I'm sorry, Your Honor, what was the bond again?
$500.
$500.
Your Honor, as a condition of pretrial release in the resisting an officer case, the state requests that the defendant possess or consume no alcohol or drugs as part of any release. In addition, the state requests no driving to be an explicit term of pretrial release as far as the driving on a suspended license charge goes.
Muy bien, en cuanto a estos cargos, la Oficina de Antelación al Juicio está solicitando que no pueda poseer ninguna bebida, ni ninguna bebida alcohólica, drogas o algo durante el tiempo que dure la libertad condicional antes de juicio, y en cuanto al otro cargo, que no pueda manejar bajo ninguna condición mientras esté en libertad anterior a juicio.
And these conditions apply for both cases. The defendant's to comply with all court orders, appear at all future court dates, refrain from any criminal activity. He's not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription.
Muy bien, estas condiciones van a aplicar a ambos casos. Él no puede cometer ningún nuevo delito, no puede faltar a ninguna cita en el tribunal, tiene que cumplir con todas las citas que tenga para el tribunal y todas las fechas que tenga que venir al tribunal, nada de alcohol, droga ni ninguna medicina que no tenga una receta válida.
He is also not to drive without a valid driver's license.
Tampoco puede manejar si no tiene una licencia válida.
All right. Thank you very much, sir. Mr. Camacho Tapia, you can have a seat.
Muchas gracias, señor Camacho Tapa. Se puede sentar.
And next court date on demand.
La próxima fecha en el tribunal será cuando se solicite.
Our next case is, I believe it's 2005 TC 1422 State versus Gerardo Montero. Good afternoon, Mr. Montero. Can you hear me?
Buenas tardes, señor Montero. ¿Me escucha?
And
Yes.
do you require the services of a Spanish interpreter, sir?
¿Usted necesita?
Okay. So, Mr. Montero, in this case, there was a warrant issued for your arrest for failure to appear, and that warrant was issued on April 1st of 2005.
Muy bien, en este caso hubo una orden de arresto porque usted no compareció al tribunal. Esa orden se emitió el 1 de abril del 2005.
Are you asking to have the Public Defender's Office be appointed to represent you today?
¿Usted está pidiendo que se le nombre a la oficina del defensor público para que lo represente el día de hoy?
Sí.
Yes.
I will appoint the Public Defender's Office to represent you, sir.
Muy bien, estoy nombrando a la oficina del defensor público para que lo represente.
And do find that there is probable cause on your failure to appear.
Y estoy determinando que hay causa probable por no haber comparecido al tribunal.
But I'm going to set bond at $1,000.
Y le voy a establecer la fianza en $1,000.
I think if it was all that important that he would have gotten served sooner than 18 years later.
Yes, Your Honor.
All right, sir. So I've set bond at $1,000. The conditions of your bond are to comply with all court orders, appear at all future court dates, refrain from any criminal activity, no consumption of any alcohol or illegal narcotics or any prescription medication without a valid prescription, and no driving without a valid driver's license. Okay,
Muy
sir?
bien, usted tiene que cumplir con todas las órdenes del tribunal mientras esté en libertad condicional anterior a juicio. También tiene que comparecer todas las citas que tenga en el tribunal. No puede cometer ningún delito nuevo, no puede consumir alcohol, ni drogas, ni ninguna sustancia ilegal y ninguna medicina para la cual no tenga receta. Tampoco puede manejar si no tiene licencia válida.
Next court date, if in custody, February 23rd at 8:05 a.m. in courtroom 4A. If out of custody, March 10th at 8:30 a.m. in courtroom 5B.
Muy bien, la próxima comparecencia en el tribunal, si permanece detenido, va a ser a las 8:05 de la mañana el día 23 de febrero en la sala 5A. Si está bajo libertad, va a ser el 10 de marzo a las 8:30 de la mañana en la 5B.
Thank you, sir. You can have a seat.
Muchas gracias, se puede sentar.
Our next case is 2023 CF 511 State versus Christopher Moreno. Good afternoon, Mr. Moreno. Can you hear me?
¿Me escucha, señor Moreno? Yes.
All right. And, sir, in this case, you have been charged with possession of a controlled substance without a prescription, that being fentanyl.
En este caso, usted está acusado de posesión de una sustancia controlada sin receta, que sería fentanil.
You've also been charged with possession of a controlled substance without a prescription for possessing methamphetamine.
Y también está acusado de posesión de una sustancia controlada sin tener una receta para metanfetamina.
And then finally, in count 3, misdemeanor possession or use of drug paraphernalia.
Y en el cargo número 3 es una posesión, delito menos grave de parafernalia.
And are you asking to have the Public Defender's Office appointed to represent you for today?
¿Usted está solicitando que el defensor público lo represente el día de hoy? Yes.
The court will grant that request and appoint the Public Defender's Office to represent you for today's proceedings.
El tribunal entonces va a concederle esa petición y vamos a nombrar a la oficina del defensor público para que lo represente por el día de hoy.
Having reviewed the uniform charging affidavit, I do find that there is probable cause.
Habiendo revisado la declaración jurada de los cargos, entiendo que existe causa probable.
As to count one, possession of a controlled substance without prescription with fentanyl, the court sets bond at $2,500.
En el cargo número 1, que es posesión de sustancia controlada, en este caso fentanil, la fianza $500.
As to count two, possession of a controlled substance without prescription to wit methamphetamine, the court will set bond at $2,500.
En el segundo cargo, que es posesión de sustancia controlada, en este caso metanfetamina, la fianza va a ser $2,500.
And as to count three, possession or use of drug paraphernalia, the court sets bond at $500 for a total of $5,500.
Y en el cargo número 3, que es la posesión y uso de parafernalia de droga, la fianza va a ser $500 para un gran total entonces de $5,500 por completo.
The court also imposes the following special conditions of bond,
También se van a establecer las siguientes condiciones especiales de fianza,
which include compliance with all court orders, appearance at all future court dates,
que incluye el comparecer a todas las citas en el tribunal que tenga en el futuro y todas las órdenes tiene que cumplirlas.
refraining from any criminal activity.
No puede participar en ninguna actividad criminal.
You're not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription.
No puede consumir nada de alcohol ni de ningún narcótico ilegal y ninguna medicina recetada para la cual usted no tenga receta.
And you're not to drive without a valid driver's license.
Y tampoco puede manejar si no tiene una licencia válida.
All right.
Your Honor?
Yes.
The state would also request no return to the Circle K where this is alleged to have occurred.
La Fiscalía está solicitando que no pueda regresar al Circle K donde sucedió estos eventos.
Okay. And no return to the Circle K gas station where the incident occurred.
Thank you.
Muy bien, pues se ordena que no puede regresar al Circle K, a la gasolinera donde sucedieron los incidentes.
Thank you, sir. You can have a seat.
Muchas gracias, eso es todo, se puede sentar.
And counsel, I believe those are all of the individuals that required a Spanish interpreter, but can you double check for me?
Mr. Interpreter, could you ask the room if they need an interpreter?
Sure. ¿Alguien más que necesita traducción a español? Por favor, levante la mano.
Yes, Your Honor, there does seem to be one more.
Okay.
I guess, Your Honor, Guillermo Ortiz Pabon.
All right. Good afternoon. Mr. Ortiz Pavon, can you hear me?
¿Me escucha, señor Ortiz Pavón? Yes.
And this is case number 2021 CF000677. It appears that that is the Orange County case number for you, sir.
Muy bien, tenemos aquí que usted tiene el caso 21 CF 677, que es el caso de Orange County.
And you were arrested, sir, on an out-of-county warrant in that case.
Y usted fue arrestado por una orden de arresto de fuera de este condado por ese caso.
For violation of probation.
Por una violación de probatoria.
With the underlying charges being an aggravated assault with a deadly weapon.
Donde el cargo es agresión agravada con arma mortífera.
So, sir, you wish to have the public defender's office appointed to represent you?
¿Usted desea que le nombren al defensor público para que lo represente? Yes.
Having reviewed the charging affidavit and the paperwork we've been presented with, I do find there is probable cause. But your bond has already been set, or you've already been held on a no bond status, and your bond's set at 0, so your bond will remain at 0, and Orange County will arrange for your transport from the Osceola County Jail.
Habiendo revisado la declaración jurada, encontrando causa probable por los cargos que se le están imputando, y como esto es un caso de orden de arresto por una violación en otro condado, la fianza ya se ha establecido en 0, o sea, no hay fianza, usted va a ser detenido hasta que de Orange County lo vengan a recoger, se le va a informar a Orange County para que lo recojan lo más pronto posible. Ok.
You can have a seat.
Muy bien, pues te puedes sentar. ¿Alguien más que necesite intérprete? Levanten la mano.
Yeah, Your Honor, it seems one of the persons in the case to do.
Okay. Who do we have joining us?
Your Honor, it's Enrique Torres Alicia. Third from the bottom.
Aha. All right. Good afternoon, Mr. Torres Alicia. Can you hear me?
¿Me escucha, señor Torres Alicea? Yes.
Sir, you have been charged with driving while license suspended or revoked as a habitual traffic offender, this being your second or subsequent offense.
Usted está acusado de manejar con licencia suspendida como delincuente habitual, ya que esta es su segunda ocasión o más.
Okay. It indicates that you are out on probation currently.
Y también indica que usted actualmente se encuentra fuera bajo probatoria.
Do you wish to have the Public Defender's Office appointed to represent you for today?
¿Usted desea que se le nombre el defensor público para que lo represente el día de hoy? Yes.
Okay.
¿Puedo decir algo?
Can I say something?
Well, first, I'm going to appoint the Public Defender's Office to represent you.
Primero que nada, it has nothing to do with the case.
Okay, why don't you talk to your attorney who's there with you before you decide to make any statements?
Hable con el abogado primero antes de que usted decida decir nada.
Your Honor, my client just wanted me to make an argument for release, Your Honor.
Mi cliente quiere que yo haga un argumento para ser liberado,
Okay.
Or terms of release. Yes, Your
para
Honor.
los términos.
Mr. Torres has indicated that he's the sole caretaker for his 14-year-old son, who has just recently fractured his back quite badly, and he would ask Your Honor's grace in setting terms of release so that he might be able to care for his son.
Muy bien, él está indicando que él es el único proveedor para un niño de 14 años que se acaba de fracturar la espalda en una forma bastante severa y estamos pidiendo la indulgencia del tribunal para imponer términos que él pueda ser liberado y salir bajo fianza. Please.
I do find that there is probable cause
Yo estoy determinando que sí existe causa probable
in this case, but it's to count one and bond. I'm setting bond at $2,000.
Para el cargo número 1 tenemos una fianza de $2,000.
Your special conditions of bond include complying with all, bond is at $2,500.
Perdóneme, las fianzas son 2,500.
And that's as indicated on the charging affidavit that's already been submitted.
Y esto aparece en la declaración jurada de los cargos que ya se había sometido.
But the special conditions of your bond are to comply with all court orders, appear
Las
at any,
condiciones especiales de la fianza son que tiene que cumplir con todas las órdenes del tribunal,
appear at all future court dates, and
tiene que
refrain from
comparecer a
criminal
todas las
activity.
fechas, tiene que comparecer en todas las fechas que se le indique en el tribunal, tiene que evitar cualquier actividad criminal,
No consumption of any alcohol or illegal narcotics or prescription medication without a valid prescription.
no puede consumir nada de alcohol, ni ninguna droga ilegal, ni ninguna medicina recetada para la cual no tenga una receta válida.
Okay.
And no driving without a valid driver's license.
Y no puede manejar si no tiene una licencia válida.
Okay.
Yes, I find that there has been a violation of probation for the new law violation in this
Y
case.
estoy determinando que hay una violación de probatoria al haberse erradicado un nuevo cargo de violación de ley.
And for that reason, probation will be terminated.
Y por esta razón se va a dar por terminado la probatoria.
Or just my finding of the violation of probation, not
O sea,
probation.
la determinación es que se violó la probatoria. La determinación de si se va a continuar o no viene más tarde.
And in that case, are you setting bond?
Yes, the bond with VOP would be $2,500 as well.
Y la fianza por la violación de probatoria va a ser 2.500 también.
Next court date on demand.
I'm sorry?
Your next court date is on demand.
La próxima fecha en el tribunal va a ser cuando se solicite.
No voy a poder salir.
So I won't be able to get out?
No, I set bond in your case on your first on the underlying charges of this new case at $2,500.
No, se impuso una fianza de $2.500 por el nuevo caso.
And I've also set bond on your violation of probation because you're out on probation when you picked up these new charges. I've set that at $2,500.
Y también se impuso una fianza por la violación de probatoria porque violaste la probatoria al cometer un nuevo cargo, un nuevo delito estando en probatoria y esa también son 2.500.
Y puedo pagar ese dinero y salir.
So I'll be able to pay that money and get out?
If you can make bond, yes.
Si puedes pagar la fianza, sí, vas a salir.
Gracias.
Thank you.
All right. Thanks, sir. You can have a seat.
The interpreter needs the case numbers, Your Honor.
I'm sorry, the case number for that last case is 2023 CF 515.
515. And the violation, the VOP?
The violation of probation was the new law, driving while license suspended as a habitual traffic offender.
But I need the case number for the original probation case.
Let's see.
It's 21 CF 3659.
I couldn't hear that.
21 CF 3659.
3659.
Uh-huh.
Thank you, Your Honor.
Thank you very much for your help. I'll go ahead and disconnect.
Very well. Have a good day.
Thank you, you too. Next, we have Mr. Paul Anthony Lindo. Afternoon, Mr. Lindo, can you hear me?
Yes, sir.
Okay. Looking at the paperwork I have in front of me today, I don't see any indication, but are you able to afford an attorney to represent you, sir?
Yes, sir.
And would you be asking to have the Public Defender's Office appointed on a provisional basis to represent you today?
Yes, sir.
All right. I'm gonna go ahead and do that and appoint the Public Defender's Office to represent you. But sir, in this case, you have been charged, there's a warrant out from your arrest for underlying charges of possession of cocaine. And I do find probable cause exists in this case. Your bond has already been, determined at $1,000 on the underlying charge. So I'm going to keep that bond at $1,000. And where was the Alpha County warrant from? I'm trying to find that. Okay. And so we'll have Orange County arrange for your transport on that out-of-county warrant then, sir, okay?
Okay.
All right, thanks, sir, you can have a seat. Next up, we have case number 2022 CF 5601-0. Looks like that's an Orange County case number. Mr. Gerald Mano. Good afternoon, Mr. Mano. Can you hear me?
Yeah, I can hear you.
Okay. Looks like from the paperwork that I have in front of me, you cannot afford an attorney to represent you and you want to have the Public Defender's Office appointed. Is that correct?
Yes, sir.
Okay. Then, Mr. Mano, I'm going to go ahead and appoint the Public Defender's Office to represent you. You were arrested here on a warrant out of Orange County for a violation of probation. With that pending warrant present, I think there's probable cause that exists in this case, but your bond in Orange County has been set at a zero bond amount. So that will remain unchanged, but we'll arrange with Orange County to have you picked up and transported. All right, sir?
Yes, sir.
Okay. Thank you very much. You can have a seat. Our next case is State versus Ronnie Eric Dibble. Mr. Dibble, good afternoon. Can you hear me?
Yes.
Sir, it looks like from your paperwork here, actually, there's nothing checked and nothing signed with respect to your ability to have an attorney represent you. But do you have an attorney, or can you afford to have one represent you for today?
No, I cannot afford one.
Okay. Would you be asking then to have the court appoint the public defender's office to represent you for today?
Yes.
The court will grant that request and appoint the public defender's office to represent you. But it appears, from what I can tell, you were picked up on an active warrant out of Polk County on a scheme to defraud and grand theft, dealing with stolen property, and possession of oxycodone, all of which charges have a zero bond associated with them. So I'm going to leave the bond unchanged, but we're going to make arrangements to have Polk County come and pick you up, sir, okay?
Okay.
All right, thank you. You can have a seat. Okay. Our next case is 2022 CF 1371, State versus Janie Lynn Bingham. Good afternoon, Miss Bingham. Can you hear me?
Yes,
All right. You've been detained and arrested based on a bench warrant for failure to appear in court on February the 10th. Are you able to afford an attorney to represent you?
no, sir.
Okay. And you'd like to have the public defender's office appointed to represent you, ma'am?
Yes, sir.
Okay. Then the court will appoint the public defender's office to represent you at this time for today's proceedings. And I do find that probable cause does exist for the issuance of your bench warrant, but I'm going to set bond for your failure to appear at $1,500. Okay? And the special conditions of your bond would be to comply with all future court orders, to appear at all future court dates. And that means you have to be here on time every single time for a court date. Otherwise, another warrant gets issued and you get picked up again. Okay? You're not to consume any alcohol or illegal narcotics or any prescription medication without a valid prescription. You're not to possess any weapons or firearms. No contact with the alleged victim in this case. And to refrain from any further criminal activity. All right?
Okay, thank you.
Next court date, March 3rd at 9 a.m. in courtroom 5A.
Our next case is 2021 CT 521, State versus Victor E. Cleek, C-L-E-E-K. Mr. Cleek, good afternoon. You can hear me all right?
Yes, sir.
Okay. Sir, you are here, having been arrested on a bench warrant for failing to appear in court on December the 15th in front of Judge Epperson. Are you able to afford an attorney to represent you today?
No.
Okay. And would you be asking to have the public defender's office appointed to represent you?
Yes, sir.
All right. Then the court will appoint the public defender's office to represent you here on a provisional basis. We will set your bond at $1,500. Special conditions of your bonds are to comply with all court orders, to appear at all future court dates, because that's how you ended up here today, because you didn't appear back in December. So that means you got to be here on time, every future court date. You understand that?
Yes, sir.
All right. You're not to engage in any other criminal activity while you're out on release or bond. You're not to consume any alcohol or illegal narcotics or any prescription medication without a valid prescription. And that will do it for the terms of your bond, sir. Okay? You can go ahead and have a seat.
Your Honor.
Yes.
I apologize for the interruption, but the state would respectfully request that you consider setting a higher bond at this time, given that this was a failure to appear on a VOP for a DUI.
Oh, this is a second? So this is on a VOP?
Yes, Your Honor. This was a failure to appear at a VOP status hearing in front of Judge Epperson, and this was for a DUI as the underlying offense. And I believe that he's already admitted to one violation of probation previously, from what I'm seeing.
Okay. I'm gonna leave bond set at $1,500.
Yes, Your Honor.
Your Honor, does he have an export date? Does Mr. Pink have an export date?
Just one moment. When's his next court date?
February 23rd at 1:30 PM in courtroom 4A.
All right. Next is case number 2022 CF 1306 State versus Joshua Lee Sugart. Good afternoon, Mr. Sugar. Can you hear me?
Yes, sir.
All right, sir. You are here because you were picked up on an alleged violation of probation from your underlying cases. Can you afford an attorney to represent you, or are you asking to have the public defender's office appointed? All right. Well, I'm going to appoint the public defender's office to represent you today. And in the case I do find that there is probable cause, I'm going to set bond at $2,500. With special conditions of bond being to comply with all court orders, to appear at all future court dates, to refrain from any criminal activity, not to consume any alcohol or illegal narcotics, no prescription medication without a valid prescription. You are not to possess any weapons or firearms, and you are not to return to the scene of the underlying incident or have any contact with the alleged victims in the underlying case. Okay? You can go ahead and have a seat, sir. Thank you.
Next court date, March 2nd at 8:30 AM in courtroom 4F.
Next is case number 2021 MM1924, State versus Shauna Marie Slagle. Good afternoon, Ms. Slagle. In this case, you have been arrested on violation of probation. There are 3 different violations. The first is an allegation that you failed to pay for your cost of supervision from December of 2022 through February of 2023, leaving an amount of $150 outstanding. The second violation is a failure to pay your fine and court costs with a balance due of $100. And finally, the third violation is your alleged failure to complete 50 hours of community service in total. Can you afford an attorney to represent you, or are you asking to have the public defender's office appointed?
I do have an attorney.
Okay. Who is your attorney?
Mrs. Fuentes,
When did you retain Mrs. Fuentes?
about 5 days ago.
Oh, okay. Well, Ms. Fuentes isn't here. What I'm going to do is I'm going to provisionally appoint the public defender to represent you for today. But having reviewed the uniform charging affidavit, I do think that there is probable cause for the violation of probation. But I'm going to set your bond because these are technical violations. I think I'm going to set bond in, I guess technically count 1 or violation 1 at $150, count 2 at $100, and count 3 at $300. The conditions of your bond are to comply with all future court dates and court orders, to refrain from any criminal activity, and not to consume any alcohol or illegal narcotics, and no prescription medication without a valid prescription.
Judge, I think it's just one,
Is it-
she's only on probation for 1 count, the petty factor.
Right. Right, there were just three different conditions of probation that were violated.
Typically, it's the count, so I
Oh,
think
okay.
you want the total bond or.
Oh, I see what you're saying. Okay. The total bond would be $550. Thank you, ma'am. You can have a seat. All right. Our next case is 2018 CF 273 State versus Christopher Andon Turk. Good afternoon, Mr. Turk. Can you hear me? In this case, you have been charged with a violation of probation. That those violations be consumption or the testing positive for methamphetamine and amphetamine. Are you able to afford an attorney to represent you?
Yes, I have an attorney.
And who is that, sir?
Jonathan Mills.
Okay. Mr. Mills is not present today. Would you like to have the Public Defender's Office provisionally appointed to represent you for today?
Yes, John.
Okay. And the court will provisionally appoint the Public Defender's Office for purposes today, but in reviewing the uniform charging affidavit, I do find that there is indeed probable cause on the violation of probation. And I'm going to set bond at $500. Okay. Your special conditions of bond, though, are that you're to comply with all future court orders, to appear at all future court dates, to refrain from criminal activity, which includes not consuming any illegal substances. That's what got you this violation of probation to begin with. But you're not to consume any alcohol or any prescription medication without a valid prescription, and not to drive without a valid driver's license as well, okay?
Next court date, February 17th at 9 a.m. in courtroom 5A.
All right. Our next case is 2023 MM375 State versus Lornia Michelle Jackson. Good afternoon, Ms. Jackson. Can you hear me?
Yes, sir.
All right. In this case, ma'am, you've been charged with a misdemeanor battery. Are you able to afford an attorney to represent you, ma'am?
No, sir.
Would you be asking that the Public Defender's Office be appointed to represent you for today's purposes?
Yes, sir.
In that case, the court will provisionally appoint the Public Defender's Office to represent you on a provisional basis. I do find that there is probable cause for the charge of battery, but I'm going to set bond at $2,000. Your special conditions of bond, ma'am, are to comply with all court orders, to appear at all future court dates, to refrain from any criminal activity, not to consume any alcohol or illegal narcotics or any prescription medication without a valid prescription, and you are not to have any hostile contact with the victim. Okay?
Your Honor,
Yes.
would the court consider an additional requirement being to maintain separate residences?
Yes, sorry. While you can still have contact, albeit no hostile contact, I am going to require that you and the victim maintain separate residences.
Your Honor, she qualified for bond with PTR?
Yes. All right. Thank you, ma'am. You can have a seat. Our next case is 2023 MM378 State versus Mark Brown. Afternoon, Mr. Brown. Can you hear me?
Yes, sir.
All right. Sir, in this case, you've been charged with 2 counts, one with a misdemeanor battery, and 2, resisting an officer without violence. Now, are you able to afford an attorney to represent you, or are you requesting to have the PD's office appointed?
I'm requesting the public defender's office.
Okay. The court will appoint the public defender's office to represent you on a conditional or provisional basis. And I do find that probable cause exists in this case. However, sir, you qualify for direct pretrial release without the setting of a bond. So you're going to be released today with no bond being set, but you will have to comply with all conditions of the pretrial release program. Okay? All right.
Next court date on demand.
Your Honor,
Yes.
given the fact that this was a battery, the state would ask that you consider setting a bond, and if not, the state would request that as a condition of being released into the PTR program, that there be no contact with the alleged victim and no return to the location where the incident is alleged to have occurred.
Okay.
It's not? Okay, thank you.
No. I'll include that you're not to have any contact with the victim or any witnesses. I think that's pretty standard.
Thank you.
We released the PTR without bond being set. So, thank you very much, Mr. Brown. You have a seat. Our next case is 2023 MM380 State versus Paul Lido.
We already did this, no, we don't.
Oh, I must have.
I believe Ronnie Pagan is next, Your Honor.
Yes. I don't know how I have Mr. Lido in there. Watch for some reason. In any event, 2023 CF 512 State versus Johnny Pagan. Mr. Pagan, can you hear me?
Yes.
All right. Sir, in this case, you have been charged with 3 counts. First count being grand theft greater than $750. Count 2 is criminal mischief, and count 3 is theft and resisting the recovery of property from the store. Are you able to afford an attorney to represent you, sir?
What?
Are you able to afford an attorney to represent you?
No.
Okay. In that case, the court will appoint the public defender's office to represent you on a provisional basis. The court does find that there is probable cause in this case, and bond is set at $1,000 on count 1, $500 on count 2, and $500 on count 3. The conditions of bond, sir, are to comply with all court orders, appear at all future court dates, refrain from any criminal activity. You're not to consume any alcohol or illegal narcotics without or prescription medications without a valid prescription. You are not to return to the scene of the incident and have no contact with any of the representatives of the alleged victim. Okay?
Your Honor,
You said no contact with
he's out on bond, and also Orange County 23 CF 1279 and 22 CF 14471.
Oh, there are two cases where he's out on
Yes, sir.
probation or bond?
Bond.
All right. Then in both those cases, I'm going to revoke bond and set him at a no bond status.
And Judge, for Lindo, the Paul Lindo, it looks like he had an out-of-county case that we addressed, but he also had a case here, and they were just separate in the file, so that's,
Okay.
so we addressed the out-of-county, but not the 23 MM 380 for Osceola. That was the one that.
Is Mr. Lido, is he gone?
Yes, they took him back to the Southern Line.
Okay. Because we didn't arraign him on the 23 MM 380 case. We'll reset that one for tomorrow.
Okay, thank you, Your Honor, I apologize.
That's okay.
They can bring him back, Your Honor, if you prefer.
Is it going to be much of a hassle for him?
We think it'd be best if we set him, Your Honor.
So reset them for
Yes,
tomorrow?
Yeah.
Okay, we'll reset them for tomorrow then. And our final case is 2023 CT 752 and 2023 MM 381 State versus Diadelis Soto.
Yes, sir. I do have PC arguments in this case, Your Honor.
Okay. Afternoon, ma'am.
I'd like to inform the court that the alleged victim is present and would like to address the court before any bond or pretrial release be determined.
Okay. Ms. Soto, in this case, there are two charges been brought against you. The first is driving under the influence, and the second is a charge for battery. The paperwork I have indicates that you are unable to afford an attorney to represent you, and you'd like to have the public defender's office appointed. Is that correct?
Yes, sir.
Okay. Then I will appoint the public defender's office to represent you. The alleged victim in this case, or the victim of the battery, is also here. But we'll hear argument from counsel for the defense to begin with as to probable cause.
I apologize. I was talking to my client. Could you repeat what you just said?
Oh, yes, I'm sorry. So we do have the victim of the alleged battery here present in the courtroom, but you'd indicated that you had an argument as to probable cause
Yes,
that the court will entertain.
As to both charges, Your Honor, as to the driving under the influence, I argue, Your Honor, the officer in the arrest affidavit, as the four corners of the arrest affidavit, it doesn't indicate whether the car was on. It does indicate that the car was not being driven by my client at the time. So, Your Honor, I don't see how there's probable cause that there was driving occurring or that she was in actual physical possession of the car. If it doesn't say she had the keys in her hand and it doesn't say the car was on, just being in a driver's seat does not indicate that you were driving the car, Your Honor. You have to have the ability to drive the car. There's no indication in the four corners that she was able to do that. As to the battery, Your Honor, there's no indication in the arrest affidavit whether the touching was unwanted or that whether he gave permission for the touching. In fact, Your Honor, it indicates that the victim advised he did not want to press charges. Additionally, Your Honor, the only other witness that did witness this incident indicated that she could not determine who the primary aggressor was, which indicates that there was perhaps physical violence going on both ways, Your Honor. There was no way to know who started the incident. And finally, Your Honor, I'll say that the alleged victim in this case, who is the only witness in the arrest affidavit that can say whether a battery actually occurred, was admittedly, it seems, rather intoxicated himself. So the only witness that the officers talked to that indicated a potential battery occurred was intoxicated. It was the alleged victim who didn't even indicate that it was an unwanted touching, Your Honor.
Your Honor, if I may.
Yes.
Firstly, whether or not the victim was intoxicated is completely irrelevant. There are plenty of victims of crimes who are intoxicated, and yet they are still victims. Secondly, in terms of the DUI, whether or not she was sitting behind the wheel, it does say that Ms. Diadelis said that she was the designated driver, and she was helping her husband of 2 years make it home. In addition, so that is the probable cause when it comes to the DUI. And of course, there's everything else in the officer's affidavit, which discusses her impairment. As we know, she was sitting behind the wheel. In addition, in terms of the battery, the officer's affidavit says, victim stated, defendant pushed him on his chest and he went to lay down on the floor to cool off. Victim advised once he got up, Diadelis pushed him again. Victim was too distraught to provide any details or further information. Your Honor, whether or not there was consent is something that can come up as part of the defense at trial or a motion to dismiss. It is not relevant when it comes to whether or not there's probable cause to believe that a battery occurred. We have a statement from a victim who told this officer that this occurred.
Defense, any further argument as to probable cause?
Yes, Your Honor. I would just say that regardless of whether my client said that she was the designated driver or not, people can be wrong, especially rather intoxicated people can be wrong, Your Honor. Just because I say I'm the best attorney in Osceola County doesn't mean that I necessarily am. Sorry, a bad joke, Your Honor. Your Honor, I would just say that just because someone says they are a driver does not mean that they are driving. Especially my client has now informed me that her battery actually wouldn't turn over that night, And so the car was inoperable, basically, Your Honor. There was no way for a person to drive that car. In addition, as to the battery, Your Honor, it is entirely relevant and entirely necessary for the officer to have probable cause of each element of the crime. One of the elements of battery is that it is an unwanted touching. There's no information in this affidavit that says that an unwanted touching occurred.
I find that probable cause does exist for both charges. I think that there's, not every single element of every crime has to be laid out in the charging affidavit. But there has to be probable cause that evidence or that a crime occurred. I think there is probable cause as to both the battery charge. It's indicated that the defendant pushed the victim on his chest. He went down and lay on the floor to cool off. He got up and he was pushed again. I think that satisfies at least probable cause to believe that a battery occurred. As to the driving under the influence, I think it's enough to show that the defendant had the ability to exercise actual physical control over the car. It indicates that the car was parked on the right side of East Osceola Parkway just past a stoplight. That there was yelling coming from the vehicle and the defendant got out of the driver's side of the vehicle. I think there's enough to establish at least probable cause for the DUI, but I'm going to set.
Your Honor, prior to setting bond, could you hear from the victim?
Okay. And now we'll hear from one of the alleged victim in this case, who's here present. If you'll come forward, sir, you can. If you'll raise your right hand, we'll swear you in.
Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Go ahead.
Good afternoon, Your Honor.
Good afternoon, sir. First, can you tell me your name and your date of birth?
Asjet Sanchez, 0205-2000.
Okay.
I apologize, Your Honor. We're having a little bit of trouble hearing the alleged victim. If you could scoot a little bit closer to the microphone.
You'll speak right as close as you can to that microphone and speak up as loud as you can so they're able to hear you.
Yes, sir. When the car broke down, we both got out the car. Well, I was intoxicated. I was throwing up. She was telling me to throw up outside the car. That was where the push came from. When the officer came, I was completely intoxicated. When the officer came, that's when I got a little bit of consciousness. My thing is, I was always talking to the officer. I was not aggressive, nothing. I wanted, any question he was asking me, I was answering. He did say, where were we? We're Valentine's Day, we're on a date. We came out of there. When the officer came, he started talking to me. He asked me, the situation with the car, they towed it right there and then. It overheated. In that scenario, I was completely unaware of what was happening with due to the fact that I was intoxicated. So I wasn't aware to call Uber at that moment. I was throwing up. She was helping me the whole time by, not throwing up inside the car at all, sir. When the officer was asking me questions, what I do remember, and me being honest with the officer is, he asked, in no way did I feel threatened by my wife at all. Just seeing this situation play out how it is, it breaks my heart, my soul right now. And he did ask me, communicating with the officer as much as I could. Any question that he had, I would answer. He asked me, did any push? Me thinking of what happened. The push came from me wanting to throw up in the car, but her helping me to throw up outside. That's where we sat outside. That's how we got outside of the vehicle in the first place, because I was just throwing up. And I want to say that if me not being intoxicated like that, me completely unaware of what was happening during the whole thing until the officer came, that's when I gained my conscience. I had to sober up somehow, some way, because I wanted to talk to him, give him all the details that he was asking, sir. And once again, I came here, even the signature that and for him to, I don't even remember even signing any of this, sir. I can show you the signature. It was just a scribble. My mom came to pick me up. He has, if I had any right to go home, my mom came to pick me up. My mom was there the whole scene. I wasn't in no threaten. I was in no tears. I simply knew the situation was happening, and then I didn't even know about the battery charge until the next day when I called to check up on the status on her. And when they told me about the battery charge, I was completely surprised because, once again, I had no idea that the battery charge was even onto that. And here it says I'm the victim, and sir, not ever have I been any threatened, any in that type of way. And for this to hear all of this right now, it really does break my heart, and I want to tell you completely everything, sir.
Well, thank you for taking the time
Thank you, sir.
to speak with me today. Having considered the facts of this case, as to count 1 for DUI, I'm going to set bond at $1,000. And as to count 2, battery, I'm also going to set bond at $1,000. So that means you'll be able to bond, or we'll set a fairly low bond on both of those counts. But the special conditions of bond are going to be that you have to comply with all court orders, appear at all future court dates, maintain contact with your attorney, refrain from any further criminal activity. You're not to consume any alcohol or illegal narcotics or take prescription medication without a valid prescription, and you're not to drive without a valid driver's license. I'm not going to impose any conditions of no contact or even no hostile contact between the parties based on the testimony that we've heard here today. I don't believe that is something that is necessary to secure your safety, sir, or the community's safety. So I'm not going to impose any conditions like that. Okay.
Can I ask one more question, please?
Yes.
For the battery charge, I just want to have a clarification because I know I don't want for that to go on a record when.
So the only thing that's been done right now for today is I've arraigned your wife on that charge. There hasn't been any kind of conviction, nothing on her permanent record right now. All that exists is there has been a charge that she's been arrested on, and that is it so far.
Okay, yes, sir.
But you will, since the Public Defender's Office has been appointed to represent her provisionally, if she makes bond, then she'll be able to get out. But you will be able to talk to her attorney about those things.
Thank
okay?
you. Yes, sir.
All right.
So much.
Thank you, sir.
Thank you.
She qualified for bond with PTR.
Yes. Yes. So that means that she, with bond, she qualifies for the pretrial release program as well. Okay. And I believe that is our last case for today.
Thank you, Your Honor.
Thank you very much, Joe. Appreciate it.
Yeah, excuse, Your Honor.
Yes, you may. Thank you. Mr. Savage, Mr. Ramos, thank you for bearing with us today.
I'm not here tomorrow, I'm off tomorrow.
Oh, you are? Enjoy.
So I think I still maybe.
Yeah. I keep thinking it's like still Wednesday.
All right, see you later.
All right, have a good weekend.
Okay, you too.
Or actually, have a good couple months. I won't see you for a while.
Okay.
Those are all the ones that we did. This is the one that we're resetting.